much audible and good to see you, so smiling and loving faces on this
Thank you,
beautiful.
ma'am.
Thank you.
Your name?
Ma'am, I'm Anushri Chaturvedi.
Asha,
Anushri.
your name is not getting reflected actually here.
Ma'am, actually,
Key
we have
login
joined
hua
from a
Yeah.
different laptop. We had some technical issues.
Ma'am, I'm getting in touch with the other panelists also. Just in a couple of minutes, they will be joining. Uh, so,
How's Risham, Ritu,
All good.
and Sarika? Sanjum, I would like to apprise that there will be some network disturbance on my part. So please bother, I'm not bothering you. I'm just trying to my level best. But if there is a network issue, so please have patience in this regard. Thank you.
okay, ma'am. Sure. I request the anchors to please start the session.
We welcome our esteemed panelists. We may now give a brief introduction of all the panelists present in this panel session. A very good morning to all of you. I, Ananya Sani, accord a warm and cordial welcome to one and all present here. Leadership is not about standing out, it's about making a difference and leaving a positive impact on those around you. We now welcome a person of profound academic and a person who has consumed herself to change the society and light the darkness in the life of the students. Professor Dr. Ritu Gupta, ma'am, is a distinguished professor of law at National Law University, Delhi, with 21 years of teaching experience. She serves as the research director of the Center for Business and Financial Laws at NLU Delhi. Her expertise lies in commercial and business laws, focusing on areas such as contract law, banking law, property law, and competition law. Professor Gupta has authored two books, one on sexual harassment at workplace and the other on law of contract, both published by LexisNexis. She is an external expert member of various internal complaints committees, including those at the Cabinet Secretariat, Prasar Bharati, and the Ministry of Women and Child Development. Additionally, Professor Gupta serves as the policy advisor at NLU Delhi, advising on issues related to workplace sexual harassment. She is renowned resource person conducting training programs and workshops on gender sensitization and contract management for various governmental bodies and organizations. Professor Gupta's contribution extend globally as she has presented papers and attended academic events in several countries. She holds memberships in prestigious organizations like the National Human Rights Commission's core group of women and serves on the advisory boards of referred journals and magazines. Recognized for her outstanding contribution, Professor Gupta has received achievements such as Rex Karamveer Global Fellowship and Karamveer Chakra Award for her work in women empowerment. Additionally, she has been honored with the title of Miss Super Brain Super Personality in a national level competition. Honor is not a matter of any man's calling merely, but rather of his own actions in it. Dr. Preeti Jain ma'am is currently working as professor with over 20 years of experience in teaching, research, and academic administration at Department of Law, Kurukshetra University, Kurukshetra. Apart from teaching, she has been associated as resource person with Human Resource Development Center, Women's Study Research Center, and Faculty Development Center of Kurukshetra University, national and international seminars, workshops on issues pertaining to environment, women empowerment, and capacity building of women. She has been instrumental in diligently promoting women empowerment through training to stakeholders of Indian Institute of Wheat and Barley Research, Karnal Rajiv Gandhi State Institute of Panchayati Raj and Community Development, Nilokheri, Extension Education Center, Nilokheri, Haryana, and other different colleges of Haryana. She has recently organized a course on gender issues and diversity management. Dr. Jain has undertaken a project on implementation of Manrega, a social study, and has published a number of research papers in national and international journals. She has associated with different universities such as member of Board of Studies, selection committees, screening committees, and other assignments. At present, she is working as director of HRDC Kurukshetra University. She has also honored by Haryana State Women Commission for her contribution in social service. We welcome you, ma'am. A great person attracts great people and knows how to hold them together. R.H.A. Sikandar Sir is an advocate on record at Supreme Court of India. He also practices in High Court of Delhi and various tribunals. He is standing counsel for Delhi Commission for Protection of Child Rights, legal consultant at Delhi Police and consultant at the National Human Rights Commission. He is also an adjunct faculty at various law schools in India. His core areas of practice include constitutional law, criminal laws, economic offences, counterinsurgency laws, corporate laws, and women and child laws. He is regularly invited by various departments, organizations, and law schools and universities across the country to conduct legal workshops and training and speak on different topics. We welcome you, sir.
Education is not acquisition of knowledge, but formation of character. A warm and cordial felicitation to one and all present here. I, Anushri Chaturvedi, welcome you all in this panel session. Please welcome our esteemed guest, Dr. Ruchi Sapahia, an accomplished scholar with great expertise in the legal sphere. The educational journey of Dr. Sapahia spans several expertise in the legal sphere, in prestigious institutions and fields of study, beginning with a BA LLB degree from the RV Institute of Law in Mohali, Punjab. The academic pursuit continued with the Masters of Law from Punjab University in Patiala. Subsequently, a PhD was attained from Kurukshetra University in Kurukshetra, Haryana. culminating in 2011. Further academic achievements include a postgraduate diploma in criminal justice from the Indira Gandhi National Open University in 2018, along with successful qualifications in the UGC NET examination in December 2005. Dr. Sapaya has taught in the Punjab College of Law, Punjab, Regional Centre Dharmshala in Himachal Pradesh, and Rajiv Gandhi National University of Law, Patiala, in Punjab, before joining the Himachal Pradesh National Law University in Shimla. She has also delivered lectures at the Himachal Pradesh Judicial Academy, Himachal Pradesh, and Jail Training School in Punjab, etc. She has set and evaluated papers of judiciary and is associated with the Public Service Commission. She has more than 20 research papers in her credit at national and international conferences. She has participated and presented more than 55 research papers at national and international seminars, conferences, etc. She has chaired and co-chaired many sessions at national and international seminars and conferences. She has also cleared the Army SSB JAG branch exam. The area of interest lies in criminal law and civil law. Welcome, ma'am. True leaders don't wait for the title to make an impact on their organization. They focus on results. We feel honored to have with us Mr. Chaitanya Singh, who is an independent Delhi-based advocate, mainly practicing criminal law before the Delhi courts. He has completed his master's from the University of Bristol as a Think Big scholar. His diverse skill set encompasses areas such as criminal or white collar and commercial litigation, corporate legal compliance, and contracts management, mediation, and arbitration. Currently, he is engaged in various matters, including civil suits, white collar criminal cases, E Cigarettes Act, Arbitration Act, rape laws, suspension of sentence after conviction, alteration of contracts, bail laws, evidence tampering, etc. As a legal director of an NGO and education initiative based in Delhi, he is assisted in developing and delivering learning materials for the team and assisted in engagement activities to equip students with necessary skills and knowledge regarding commercial laws, constitutional laws, and consumer awareness. He has also conducted capacity building activities for the key management persons and underprivileged students. Welcome, sir. Now I invite our distinguished panelists to take the floor and initiate the discussion.
Before that,
Yes.
let me also welcome Dr. Ritu Gupta ji.
Namaskar, sir. Thank you so
Namaskar,
much.
madam. Dr. Priti Jain, Dr. Ruchi Spaya, Mr. Chaitanya Singh, advocate, and Mr. R.H.A. Sikandar, again advocate. This is a very good combination of eminent professors and advocates to discuss such a vital issue, or new three criminal laws, which will be threadbare discussed by all the panelists, and it will be a pleasure for us to hear your views. It reminds me of what American philosopher Emerson has said once. There is no better way to exercise imagination than the study of law. And there is no javel in the world which is comparable to learning, and no learning is complete without the study of law. A lawyer thinks more than anyone else. This professional, whether he is a teacher or an advocate or a judge, he thinks more than any other professional. Somebody asked 2 plus 2, engineer says 4. They ask a chartered accountant 2 plus 2, he says 4. They ask a lawyer 2 plus 2, and his answer was how much you want. He's still thinking 2 plus 2 could be more than 4 also, could be less than 4 also. So this is a very good combination of the professor who teach law and the advocate who practices law in the court. what difficulty they're going to face by interpreting these laws. I also gone through some part of this provisions of Bharatiya Nyaya Sanhita and Sakshya Adhiniyam and other law, which is corresponding criminal procedure code. 2-3 points which I noted. The one is that this act, Bharatiya Nyaya Sanhita, uses two terms. One is life imprisonment, other is life imprisonment, which means the remainder life of that person. Punishment for murder is life imprisonment or death. But there are certain provisions where the punishment has been, mentioned like life imprisonment, which means the remainder life of that person. So this will be interpreted in different way, especially when the president exercises his power of pardon and governor exercises power. That may create some problem. The second is like those who the 2% adults, male, female, they live together, and man promises to marry. If doesn't marry, then the punishment is up to 10 years RI. This again is going to create a problem. Whether he promised to marry or not, that thing will come. So there are certain provisions which are like the offense of adultery was struck down by the Supreme Court. Okay, you can't treat a woman as a subject, as an object. Same thing may come here in enticing woman. Enticing a married woman, it will fall in the same sort of thing, adultery, and then here you are using women as an object. Their adultery was struck down with the Supreme Court. You can't treat women as an. So there are certain provisions which may create certain problems. Let's watch and see how they will be interpreted in the courts. And lastly, I again thank all the panelists who have joined from very reputed law schools, as well as these advocates who everyday practices this profession. I joined army because I wanted to become a judge also, I wanted to become an advocate also, I wanted to become a general also. Then I thought, which is the field where I can be all three together? Then I thought army is better. Here you are a judge also, you are an advocate also, you become general also, which is not possible outside. Thank you very much, and we'll hear your arguments, your views on these topics. Thank you very much.
Good morning, everyone. I hope I'm audible.
Yes.
I welcome all the star-studded panelists that we have in the panel discussion today, and I am overwhelmed to see all of you. I just wish to take the honor of starting the panel discussion by discussing few points upon the exquisite topic that we have of the conference, that is the replacement of the three criminal laws of the British era by the Bharatiya law. Will lead to decolonization and assuring reforms. It's an in-depth analysis. So basically, the first thing that I wish to start the discussion upon is the British era criminal laws have long been criticized for their colonization and the origin that they are coming from. So reflecting and imposing this foreign legal system in India has always been, as per the jurist, a mistake. So what are your viewpoints on this statement?
I request Dr. Ritu Gupta to please take over. Yes.
Right. So thank you so much. First of all, thank you, Major General Rajendra Kumar ji, for introducing the concept. And so, Vartika, do you want me to just take up the specific question?
Absolutely, ma'am.
Okay.
No, ma'am. You can just go around it. Right. Absolutely, your choice.
Right. So, and thank you, Dr. Sanjum, for coordinating I think it's been long, and thanks for all that introduction. And I really welcome and look forward to my fellow panelists for the day, Dr. Preeti Jain and Advocate Sikandar and Mr. Chaitanya also. So many expectations I see have been raised by introducing and bringing what we have termed as that our criminal laws after these reforms we have ushered into a new era. Dr. Ruchi Sapahia is also there because we were just listening to the expertise. So per se, talking about criminal law, yesterday I logged into your inaugural session also, and Professor Nishtha Jaswal very beautifully and in her special style, she introduced what has been done by what was the motive behind introducing, and she tried to actually make us aware about that all those changes which have been talked about in all these three criminal legislations, now where are we after those changes? So in today's because I had simply planned that it's not only about comparing that what was there in the earlier legislations or what are we going to have in the newer legislations which are going to be implemented this year itself. More as an academician, what I have tried to look into, I'll just share, just allow me to share my screen. I hope you can see this. So the kind of things that I thought that I want to share with the participants of this wonderful conference that Amity Gwalior has planned, that what could be the possible and plausible impact of these reforms as far as this legal scholarship is concerned. How does the jurisprudence in these criminal legislations, so how does that impact the growth and development of that jurisprudence, and how far all the academic resources put together can actually bring in the desirable results that we really wish to seek in. So whenever we are talking about any reforms for that matter, be it criminal or be it any other, the purpose or the motive behind is that there was something, some lacunae, some void, or something which had become obsolete. And now, because of the changes, say, be it because of technology, be it because of societal changes, be it because of whatever reason, we need something which is new, contemporary, and rather more relevant to the society. So I think government has one very common thing that is usually stated about these legislations which were there earlier, IPC, CRPC, and are evident. So one thing which has been usually stated that it's like colonial in nature. So whenever something which had that colonial mindset with which that had been set up. So when we are trying to brush it aside and bring in more, where we say introducing more Indianness to that, because now we know what is our jurisprudence. Now we know that where are we and what point of progress and development our own civilization is. So this is where we are talking about all those processes. We are talking about the institutions who are going to implement and the way they envisage to, be it detection, be it, punishing the crimes, be it deterrence. So because usually the punishments that are imparted, they help in ensuring the right and safety of the people, and that is the main purpose. So this is the core that I thought that we are going to work on this. And one major shift, paradigm shift, Prime Minister Modi, when he was talking about this, he has talked about this paradigm shift, that it's more about to deliver justice, and it's not only about punishment. Yes, whenever you do something wrong, and that wrong is like seen as something which is whether minor or major in the society, but what we require, that one, that person who does wrong should be punished, and second, that others should be deterred from not indulging into the same kind or similar kind of actions in future. This is precisely after changing so many things. See, हम ठगी जिसको हम पहले बोलते थे 400 BC 420, now if you look at section 316, so it is not that making it 316, और या फिर जो एक सबसे important चीज that we have been talking about, राजद्रोह, देशद्रोह, and all those acts which make it this one. Whether the change of law was desirable or it was not desirable, I think all of us are on the same wavelength that changes were highly desirable. But the only thing is that whether these, the modifications which we have termed as overwhelming, because ultimately, as Major General Sir has talked about, that it's only going to be a matter of time that we are going to have a feel whether that modification and all those kind of updations that we thought, these were, good or bad. So that jurisprudence, when it evolves, it is only through those cases and the matters that the highest authorities, the apex court is going to decide and going to establish. But indeed, I think that not only I think, but that's like something which has always been stated, that if you need any sort of societal transformation, then you use this law as a catalyst. If you are unable to use that law as a catalyst, then what will happen, as we were talking just before this panel discussion started, I along with Dr. Preeti, we were just talking about that. If you do not establish that correlation, then things work in isolation. And being in isolation, be it whatever discipline, then it does not help. And this is where the new generation, the role of new generation of, be it policemen, be it the lawyers, be it the government councils, be it the judges working at the lower courts or working at the appellate courts, that's going to really work with the help of the changes that have been brought into the system. So whatever the way the communities are woven and all those legislations which are there, and with the help of those legislations, like the kind of aid these legislation can prove. So this is where you have to see that where we are trying to take our society, our nation, and that is where the role and importance of this legal system and these things which we now at least see, we know that the idea or the motive with which we have begun, that's noble. And I'm very sure when you start your journey or your progress with this noble thought, then of course that's going to really work. Maybe it's only a matter of time, and of course it's going to be reflective very strongly of the contemporary values. So it's not that say as many centuries we have not changed the law. The reason was not that we were not aware about that colonial mindset, or we were not aware about the existence of those laws which did not make any sense at this stage. So rather than revising or amending every time, this is the overhauling. And that overhauling, you will see and you will agree that various minds that have been there. So that is where you see that it's not only redefining, it's more about refocusing. So it's the way that jurisprudence, which was going here and there and scattered, now with the help of this particular reform, we are going to have that focus, so which was jittery. So some now with, say, if we are talking about the laws that pertain and deal with women, the way we have talked about the changes in live-in relationships or the promises, because having sex on the assurances of having marriage. So this is what we are going to witness. And of course, the system is going to be, more fairer, more transparent, and we can believe, we have reasons to believe through, because I am not going to repeat all those changes which have taken place in the system, and there are other experts who will look into this. But the kind of changes, like today itself, what we are witnessing, say in Delhi, the kind of political scenario that has come up, and how judiciary that is able to respond to that. And that is where we have to fill in that gap. So we are to have some human face to this criminal justice system. So criminal justice system, when we have been saying that sometimes the younger lot, our youth, they are clueless that what's going to, how they are going to be part of this criminal justice system, and whether all those victimological aspects or any other kind of things which make that victim more victim. So this is again another attempt by which we are trying to make this a human face, where we recognize, not only recognize, but we feel that pain of the victim, and at the same time giving that opportunity to the offender also. And of course, the way the faces of everything has changed. Say today is in era of deep fakes. Today in the era of where you can have, somebody's profile and do something to that profile, or where in this degenerative AI. So all those kinds of technological issues have given rise to more serious forms of crime, be it financial frauds, economic things, issues pertaining to political parties, talking about defamation. So all those things, I think, have been taken care of in the newer legislations. And of course, the reason has been that we need that our system should be more responsive. And it's not about every time we are talking about fundamental right to equality, it's like more focused on equity. So it has to be more equitable and better suited to the needs of the society, which are ever evolving. So I think that was much desirable in this, say, when we are talking about 2024, and all these reforms have been, for last 5-7 years, the things were in progress. And it's not that we say that these reforms, they are like everything is whenever you bring something new. So there is always a scope of that whatever you change might be for bad also, or may not achieve the goals for which it was envisaged. So my take here in this panel discussion is that it's rather more about execution and supporting the system, so that the system is able to achieve those deliverables which we had planned that we will. And this is where we have tried to remove all those historical constraints that we say. And that is where we are talking about maintaining the rule and then influencing the justice. So these are the points I think and look forward to, which my fellow panelists, because being the first speaker in the panel, I believe that my role is more to flag those issues in which the panel can, continue discussions. So this is where we are, because here more nuanced approach when we say talking about these offenses and the actions. So of course, one of the major wrongs and the crimes that have, come up, sovereignty issues, cross-border issues, and cross-border issues pertaining to all those financial reforms also, because earlier those things were not impacting. Today, even if one statement made by one political leader anywhere, and that's going to have some impact, or the kind of war that has taken place. So that war, what kind of impact it has on sovereignty issues or the other political concerns in India, which might disturb the unity and integrity of India. So this is what I think these new legislations are successfully going to regulate. And if you are talking about, of course, more organized crimes, if you are talking about issues pertaining to cross-border terrorism, so it's not only terrorism within our country, and again, the types of terrorism. So today we are even in terms of biological terrorism, or we are talking in terms of, terrorism pertaining to technology. So these are the things which this new law is aimed at. And it's not that for petty offenses, you need to have the same quantum of punishment. So this is what is very important, that you are able to somewhere by law, it's not the discretion or the will of the judge or the judiciary. There should be some well-defined criteria to segregate major offenses and the petty offenses, and that the penalty relates to both of them. So whenever it has to be, it is to fall into the category of major, there has to be that more stringent penalty. But again, as a panelist, I'm very, very apprehensive. See, when I was a student like our anchors for the day, that time I always felt, and might be many others must have felt this, that more stringent penalty you have, it's always good. जैसे हम बोलते हैं ना, आप क्यों नहीं, जैसे सऊदी में होता है, why don't you hang the rapist? Why don't you kill? आपको किसी ने मारा, आप भी मार दो. So this is where you are when you realize that no, it is rule of law that has to be supreme. And it cannot be that every time we can take the parliament in our hands, or it is not that every time we are going to just criticize the judge. आपने बेल क्यों दे दी? आपने बेल इसलिए दे दी क्योंकि आपका बायस है, क्योंकि you. So see, we have to make our, जिस हम न्याय संहिता की जो हम जिस अब बात करने लगे हैं, साक्ष्य संहिता, so that साक्ष्य संहिता becomes more transparent. This is what we are to see, and more mechanisms have been introduced in this, so that reliability of those evidences, that is like becomes more meaningful and more impactful. This is where I thought, because yeah, in yesterday's panel discussions also you have discussed many of these, but I again, as I just said, I'm just talking about those things which I consider to be strong forte of these kinds of legislations, because because I wanted to talk about the jurisprudence and the academic resources. So academic thrust is that in the class, when you are training the budding lawyers and the judges and the prosecutors, so this is where you have to see that the kind of language which is there, that has to be more people friendly, more friendly to the because these days we are advocating even in regional languages, or we are talking about Hindi languages. So one of the major thrust is this, that the same humane approach to towards this criminal, all the system that makes this criminal justice system. So whenever we are here, say in Delhi Judicial Academy, which is on our campus, we are training the judges who are on probation, or even the senior judges for their refresher courses. So again, it's not only about the language which is used there. One, that language has to be friendly. But second, आपको जब उस लैंग्वेज को जब इंटरप्रेट करवाना आना चाहिए when you are there in the court. So वो जो चाहिए वाला जो एलिमेंट है, so every time we are moving between will and shall, but sometimes there ought to be. So this is where that ought to, which we have learned in our school days, high schools, or even the primary schools, that ought to, that training part, that will become more important. And when it comes to heinous offenses, of sudden and grave nature, like see Shraddha murder case, so that Shraddha murder is not just like any other murder, or the trial of Kasab, that's not like just like any other trial. So this is where you have to see. And today, without looking at what is forensic evidence, what is the role of cyber police, what is the kind of strategies, so that strategic provisions for the investigative processes, that is where we talk about. And especially आजकल जितना सारा एविडेंस है, वो ऑन साइट एविडेंस को कलेक्ट करना, उसको प्रिजर्व करना, and then take it to the characteristic lab, and in which the time which is desirable. This is what you have to see, so that to collate that crucial evidence which was there, that is really very, very important. And when you are talking about the specialists or the experts who have been trained for all that purposes, so this is what we require. And like in these new legislations, because they are talking about that thoroughness and accuracy of these investigations based upon techniques and tools of investigation. And that is where not only that just for the sake of talking, we are to talk about that robust legal framework, but we are talking about, accessibility of the justice. So when you really want to make justice accessible, that is where in that accession you require experts, you require training grounds, and you require that jurisprudence flows in the right direction. And who is going to monitor that right direction is the kind of jurist, is the kind of legal scholars, is the kind of role on law faculties and law schools. So it's not only the conventional and traditional ways, it's more about the unconventional approach, whereby rather than just critiquing the changes that have happened, but to take them in right stride and then be able to, flow through that. So this is where you have seen, and as I talked about the Sakshay Adhiniyam, so because it talks about the, increasing impact of technology in collecting. So this is where when we are to face that landscape, when we are talking about that pivotal role, so this is where you are to see that where it is generated, where it is transmitted. So all those things, now you are seeing those right to be forgotten. So one is the constitutional right, one is fundamental right, which is a domain of constitution. But when it comes to, tempering with my right through your devices, so these devices, these gadgets, this Wi-Fi system, or this kind of, availability of easily reproductive techniques. So this is what we need to, I think, be very clear about. And this is where we are, that it's not only about changing criminal law only. So it's more about something more than a mere legal transformation, because these resonate with the changes that the society badly needed this time. So it's not only about that we have to question that why it has been done, rather more about, yes, if it is done, let's take it this way, that something good has come, and might be something is lacking, then again we are going to supplement and complement with the help of the evolving jurisprudence that we'll get to know as and when it comes to you. So there are certain situations which, when you prepare those reforms, you cannot contemplate. So this is where we are talking about that contemplation has been done, but more it's the time which is going to tell. So this is where we are. Of course, the changes are really groundbreaking. These indicate are, again, as I mentioned, that justice will not only be delivered, but more is about inclusivity. So that inclusivity, be it on the basis of, say, region, religion, language, sex, or any caste, so that inclusivity, if it is about somebody who is disabled, if there is somebody who is illiterate, or somebody belongs to a particular strata, or it's more about gender divide. So this is what we have to see, that these changes, they are going to reflect our nation's dynamic ethos. And that is what I think is the main purpose, that it has to be reflective and be very, very inclusive for everybody. But not, of course, just like any other discussion, we always cannot say that there is no fizz, that there is no fuzz, or there is not going to be any clogs or, say, bottlenecks. So they are going to be, there are provisions. I am not naming the provisions. All those tabular presentations I have seen, everybody has it on every piece of information they have put in. So there are vaguenesses which have been highlighted, which sometimes perpetuate the exercise of police powers. But that is also one of the main aims that we are working for. But of course, that kind of vendetta, if it is there sometime, you realize, then of course that is unacceptable. And that is where I think, again, whenever the right moment comes, that is where again the legal scholars will be there, the jurists will be there, and this new generation is going to be there to raise their voices about that. So this is where, if it is about appointments, see, we need experts, but what if the vacancy is there? So we look towards Supreme Court, but what if there is vacancy in the Supreme Court? So all these kinds of reforms, they go hand in hand with the political will, and of course enhancing the capacities and capabilities. So this is, I think there is still some scope to improve that. And of course, in relation to certain offenses, sometimes the illustrations which have been kept, they appear to be obsolete. But this is where I think this is how the journey has begun. And once we are saying that the journey has begun, that is where I think our task will start. And this is how, once you have kept this wheel of progress in motion, I think it will be ever evolving. So this was the first step we needed. First step when we have taken in right direction. I think when we move on, That is where all those resources which we have been spent, all the kind of jurisprudence that will be evolved. And I think we are there. And at every step, we have to monitor, we have to measure, and that is where we have to calculate and accordingly take the next step. So this is how I think I wanted to just flag all these issues and my co-panelists. So I just hand it over to Ms. Vartika for further deliberations. Thank you so much for your patience and listening.
Thank you so much, ma'am. It was really wonderful listening to you, and the phrase that you have used, that the law should be used as a catalyst. I would like to ask a question to Preeti Jain, ma'am. That do you think that using law as catalyst in this scenario will, like when we are replacing all the three laws, the indigenous all the three criminal laws with the indigenously built Bharatiya laws, is it going to any ways signify the crucial steps towards decolonization?
Yeah, thank you, Ratika, for asking this question, because my presentation or my point of view relates to this only.
That's
When we
amazing, ma'am.
when we talk about the modification of three criminal laws, and as a student of social scientists, when I found that there are the different segments of the society. When we talk about male, female, transgenders, aged, and old person, what is in these criminal laws, whether they are justified to the contemporary needs and expectations of the society. So I was just trying to locate and explore the things whether these criminal laws help a lot in the Indian society, in the person of the society or not. So will you please allow me to, share my insight on this particular issue?
Absolutely, ma'am.
Yeah,
Absolutely, please.
thank you. Thank you.
Most welcome,
So,
ma'am.
a very warm and cherished good morning to each and all present over here. It is indeed my pleasure and honor to be part of this wonderful discourse. And I would like to congratulate the organizing this particular workshop by a wonderful and amazing team. I would like to congratulate Amity Law School for this wonderful initiative. And on this particular platform, I would like to thank Professor Ritu Gupta for clearing the path that we have to move on. And as far as your query is concerned, I am just inclining myself to this particular issue itself. As far as I was going through the objective of the modifications of three criminal laws, I just find that basically objective of this modification of a criminal law is to upholding justice that was missing in the earlier laws. It was upholding the dignity and the intrinsic values of each and every segment of the society. Fine. And that's why when we take into account the provisions of the IPC, the nature of the IPC was criminal, and the whole inclination was on the penalty, not on the justice, right? So when we talk about Bharatiya Nyaya Sanhita, या भारतीय नागरिक सुरक्षा संहिता और भारतीय साक्ष्य अधिनियम, so definitely there are some provisions that deal with to promote justice and to promote equity. That was the concern of Ritu Gupta ma'am itself. We don't find to consider that we have to promote only equality. Now this is the time to promote equity also. If we talk about in the 21st century, and if we talk about the SDGs goal by 2013, so simultaneously it is very imperative and it is very expedient that now our all concentration should be on the equity, simultaneously on equality also. So I would like to share that there are something, the relevance and the significance of the BNS lies in the fact that it has renumbered, it has reconsolidated, and the different chapters related to the women and children were scattered in the IPC. The main feature of this BNS lies in the fact that it has collected all the provisions and sections in one chapter, so that we may be able to find out very smoothly, very comfortably. No doubt this will create problem, some 2 or 3 years, then we are very much used to follow these kinds of rules and provisions in this regard. But simultaneously, I would like to, emphasize that this is a good step in this regard. Earlier, we had to move on 376 A, B, C, D, then we have to move up 354, then we have to move 511, and so on. So I would like to think that this is a wonderful step in this regard. And as I'm confining myself to the women and children, what has done in these criminal laws to improve the position and to provide justice to the three segments of the society, that is the women, that is children and transgender, and what about the provisions relating to gender neutrality. So I'm just like to share my PPT in this regard. As the key salient features of BNSA, I would not like to go through in detail because already have discussed, and we as the panelists, we are very much aware of what kind of provisions have been added and have been amended. Just like keeping into the consideration of the contemporary society that was missing in 1860. There was no information technology, such kind of things, and there are so many crimes and there were so many developments in this present arena. So that's why, to address those challenges and to address those cyber crimes, this was expedient that we have to incorporate in टुकड़ों में नहीं बल्कि हम उसको एक साथ consolidate कर सकें. When we are facing with the problems of the terrorism and the mob lynching, the definition of the terrorism and mob lynching is much wide and extensive. That was the need and expediency of the time, because we are facing it a lot in the last 10 years. So that was a relevant issue. Catering to the needs of the gender justice, definitely it is a, I would like to say that this is a जो कि is very much dear to my heart, कि it means gender justice, not about the women, not about the men, or not about the other person. Bharatiya Nyaya Sanhita or the Bharatiya Nagrik Suraksha Adhiniyam that deals with the gender neutrality, and there is a specific provision in section 66 that deals with the it has been introduced that when we talk about the issuing of the summons, so gender neutrality has been introduced and have been included as an adult member of the family for the purpose of service of summons on behalf of the person summoned. The earlier reference to some adult male member, getting me, male member, not the female member. But now the time has changed. We are not in 1860. As per the interpretation of the IPC, we are only considering that the male member has a right to take summons. Not. Now this is the time to replace the words, and this has been replaced with the words some adult male member, whether it will be the male or it will be the female. So this is a significant feature in this regard, and I would like to appreciate in this regard also that it promotes gender neutrality, gender justice, not keeping the consideration of the male or the female or any other else. Simultaneously, when we talk about the children, a prominent feature in these laws is that the trade of minor boy has been considered as a crime. So I would like to say that not only the trade of a girl, but simultaneously trade of a minor boy has been included. When we talk about protecting rights of the LGBT community, we have decriminalized 377, but I am sorry to state that still, there is a figure to state that male victims of non-consensual acts have not been considered till date. So, although 377 we have decriminalized, we have considered their rights, but these issues should be addressed in this particular BNS, because this is the right time to consider if we talk about the gender neutrality or the gender justice. When we talk about the reconsideration of offense of sedition, yes, again, very much hopeful that when there was a section 124A of the sedition in the IPC, and that has the influence of the colonization, because at that time the Britishers or the colonizers were of the opinion that how they are in position to suppress the Indians and to provide and to punish them, not to provide justice. But as far as the definition of the sedition is concerned in the present context in the BNS, it is a very welcome step in this regard. Ki the sovereignty integrity is the most important thing, and that's why we have that is the basic concept of the state formation. When we talk about redefining definition, yes, it is very important and significant feature, and that was expedient, that was relevant to keep us a broader and a comprehensive understanding to the concept of the defamation, fighting mob lynching. Yes, definitely, Section 152, again prominent feature. Advancing women's right, because the 2013 we have made a comprehensive amendments after J.S. Verma's committee, and we have overhauling the all the existing provisions. But still, our society is facing some kinds of a societal deterioration and the degradation of the values and the morals in the society. So that was imperative and expedient that we have to consider once again what was missing in 2013 amendments in the IPC, what is there that has to be recognized and accepted. When we talk about, as our Professor Rajendra Kumar has already discussed in the earlier deliberations, that this particular BNS advocates women's right, and adultery has been decriminalized, although it has been decriminalized in the Joseph Shine versus in of India, but definitely it's a good step. That is not the part and parcel of the BNS, and that considers women as a chattel, as a subject, as a thing. And simultaneously, when we talk about the rape, we have Child Prohibition Marriage Act 2006, in spite of the fact we are not able to curb the menace of the child marriage, but definitely these kinds of provision will help a lot to prohibit child marriages in this regard. Whenever there is a provision in the definition of the rape itself that deals that a husband if he marries, if he intercourse with a wife under the age of 18 years, that will be considered as a rape. So that is a laudable provisions of this BNS. When we come to the disclosure of identity of victims of certain offenses, recently, when we are discussing, when we are perceiving the things, most of the time, rape victims or acid have disclosed their identity were disclosed. So that was a very serious thing, and that has to considered by the judiciary itself. And as we talk about the right to privacy is a constitutional right or a fundamental right, we have perceiving it as, so it was very important specific provisions in this regard. So again, this is the prominent feature. Section 72 of BNS deals with the disclosure of identity of victims of certain offenses, and definitely it will create confidence and justice to the women victims, so that they will be able to come out from their comfort zone to complain all these things if their name is not disclosed. When we talk about another section 69, that is the sexual intercourse by employing deceitful means, I am very much happy to share that this particular provision is the need of the day, because most of the time whenever you are tempting someone woman, as although we can say that we have progressed a lot, but simultaneously it is very important that there are some unscrupulous persons are in the society that are in position to control and manage the psyche of the women. So that's why it is the need of the time, and recent cases, our newspapers are filled of such kind of incidents and things. If you are promoting job advancement, but fine, if you are giving inducement or marriage and simultaneously concealing your identity, you are married, you have children, but in spite of the death you are compelling to someone to marry. So that's why this was an important feature of the BNS, and that's why section 69 of the BNS stipulates penalty for engaging in sexual intercourse by employing deceitful means, deceptive commitments regarding job advancement, inducement, or marriage while concealing one's identity. And simultaneously, BNS also protects the dignity, and privacy of the victims, section 72 itself. And again, in this series, when we take about section 73 that deals with the printing or publishing any matter relating to court proceeding without permission. It is again a laudable feature of BNS for the protection of the rights of the women and for the justiciable approach relating to women itself. And when we talk about assault or use of criminal force to women with intent to outrage or modesty, some kind of provision was earlier in the IPC, but it has been considered in this BNS that shows the dignity, to protect the dignity of the women in the contemporary society also. Although the provisions when I was that there are some provisions that has been still बहुत ज्यादा नहीं हुआ है, लेकिन फिर भी बहुत सारी चीजें इंक्लूड कर दी गई है जो कि पहले आपके आईपीसी में थी, वो भी आपकी यही है. तो सेक्सुअल harassment was earlier the part of IPC. Section 76, section 77 voyeurism 2013 में we have included stalkings, word gesture and intent to modesty of sections. These were provisions of the IPC were existed in the IPC itself. But there is a provision of section 80 dowry deaths, right? The provision has been more elaborated and not out about the 498 and the 304B. So all the provisions have been compiled and some kind of definition has been reframed. Cohabitation caused by a man deceitfully inducing belief of lawful marriage. Again, this is the salient feature of BNS for the protection of the rights of the women. Marrying again during lifetime of husband or wife, section 2282, that was, we have earlier chapter on the offenses against marriage, same thing is here. So section 83, section 84, or the section 85, just like, we have a particular chapter in the earlier IPC offenses against marriages, whether it will be the, enticing, whether it will be the bigamy, whether it will be the, adultery. So some kinds of things have been incorporated in the present BNS also. Husband or relative of husband subjecting her to cruelty. So some kind, there is still the part and parcel of BNS. So when we talk about children, the chapter 5th of this BNS section 93 to 99 deals with the children. And although we have POCSO Act, although we have a plethora of laws relating to it, but simultaneously it was the need of the time. And that's why the section 93 deals with the exposure and abandonment of child under 12 years of age by parent or person having care of it. So although this is a very ridiculous issue and we are discussing a lot on this regard and keeping into the consideration of the international conventions and what is going in the international communities itself about the age of 12. So let's we have to see, and we are very much optimistic to see whether this kinds of things will decrease or increase, keeping into the consideration of the international mandate also. Concealment of blood by secret disposal of dead body, same 94. Hiring, employing, or engaging a child to commit an offense, 95. Procreation of child. Provisions were earlier in IPC. Same. Now, keeping into the constant of the time, I would like to, introduce segment that is the aged or infirm parents. As I'm saying that our constitution's objective is to promote social justice, not economic, besides economic justice and political justice also. And India's tradition, when we talk about the Indianization of, 3 criminal laws, so what kind of reflection of the Indianization is manifested in our laws? So when I was going through, there is a specific provision for the aged or infirm persons. And this kind of thing shows what kind of sincerity, what kind of we have sensitivity towards our old and aged persons. And that's why I would like to draw the attention of all the panelists and all, prize before you. That is the section 35/7 of the Bharatiya Nagrik Suraksha Sanhita 2023. And there is a specific provision that protects the aged and infirm parents. We have the, Constitution and directive principles of state policies that it is the duty of the state to protect the old age or the infirmity. But simultaneously, if this is the part and parcel of Bharatiya Nagrik Suraksha Adhiniyam, then we have to appreciate it. And it has provided that no arrest shall be made in case of an offense punishable for less than 3 years if the person is infirm or above the age of 60 years. So that shows that there is some kind of reflection of sensitivity towards old persons. Without prior permission to office not below the rank of Deputy Superintendent of Police, the rights of the aged and infirm have further been protected as witnesses. Not only the arrest, but also the witnesses also. In section 79(1) of Bharatiya Nagrik Suraksha Sanhita, where no person above the age of 60 years or a person with acute illness will be required to attend at any place other than where they reside. So in Indian context, when we talk about the Vridhavastha Pension Yojana, and if person you are compelling to go somewhere else and to present yourself before the court, that will be a devastating effect in this particular age. So keeping into the consideration of that ethos, that culture, that shows that we are moving to provide justice. We are sincere and sensitive in comparison to the colonial jurisprudence. When we come to gender neutrality, I have already discussed. Some adult members have all included in this Bharatiya Nagrik Suraksha Sanhita at the time of the summoning of the issuance of the summons. Next is the order for maintenance of wives, children, and parents. Again, I would like to draw your attention to this particular provision. Earlier, we have in section 125 to 127 and the 28 something and CRPC. But now, if you see the language of this particular section, you may be able to understand what kind of approach and what kind of objectivity has been reframed in such kind of sections. So there is an important addition has been made in Bharatiya Nagrik Suraksha and section 145. And in this particular section, in case of dependent father or mother, the proceedings for order of maintenance may be initiated at the place. At the place. I'm again saying at the place where he or she resides. These remove the difficulty which existed in the CRPC, where in case of parents, the place of initiation of proceeding was the place of residence of their son. So you can see the sensitivity, you can see the accessibility, you can see how a parent in the age of the 60 or 70 wants to get maintenance from his son or daughter, तो उसको जाना पड़ेगा. But ultimately है कि आपको जाना नहीं है, but this system provides some kind of mechanism in this regard. And when we talk about चाहे वो rape victim है, चाहे आपका men के बारे में रहते हैं और child victim है, तो again this is a laudable feature of the Nagrik Suraksha Sanhita Adhiniyam. Sorry, CRPC अभी निकला नहीं है, धीरे-धीरे it will take time to things. So section 176(1) provides that in relation to an offense of rape, the statement of victim shall be recorded through audio video means. And that is the incorporation of the information technology in the criminal procedure also. And this was the expediency, keeping into the consideration of the present society, audio visual means. And before that, as my earlier panelist has also discussed, that there are some kinds of, whenever we are introducing the methods of the information technology, there will be some kinds of issues that we have to address in the coming years. Definitely, but simultaneously it is very important that we have to consider to provide a cheaper accessible means to communicate. In section 79 of Suraksha Sanhita, the exemptions from attending the police station is given to women, persons above 60 years, and a person acute illness. So definitely you can see the serenity of these kinds of provisions. Further, a proviso is added to allow the persons mentioned in the exemptions category to attend a police station if he or she is willing to do so. So we should welcome these kinds of provisions for providing justice to Indian women. That is the need, because most of the things are not come out and not effectively implemented in the absence of these kinds of provision. And when we talk about the victims of rape, it has been mandated in section 183(6)(a) that the statement shall be recorded only by a lady judicial magistrate and in her absence by a medical judicial magistrate in the presence of a woman. Those technicalities have been removed. And when we talk about the Bharati Sakshi Sanhita for the protection and for providing justice to women and child or the indigenous members of the society, witnesses also have a proper retention has been made on the witness also, and for ease the convenience of the witness and to prevent undue harassment by police, the proviso to section 195 provides that no male member under the age of 15 years or above the age of 60 years or a woman or a mentally or physical disabled person or a person with due acute illness shall be required to attend at any place other than the place in which such male person or woman resides. So when we were discussing about that, there kind of some kind of threats, that kind there will be some kinds of pressures on the victim. So this kind of this was a need of the day. In number of commissions and number of committees, it has been suggested that we have to address this issue particularly. So now, as for the protection of the witness, this particular provisions has included, and in case where such a person is willing to attend a police station, they may be allowed to do so. If मतलब consent matter करती है कि if you are willing, so you can come. Otherwise, there is a proper mechanism to address this issue. And last not the least, electronic evidence. As Information Technology Act has came into force, we have amended the definition of the Indian Evidence Act in earlier. But now electronic record as primary evidence has been considered Bharati Sakshi Sanhita. Secondary documents deals with the section 58 Bharati Sakshi Adhiniyam and zero FIR. That is a very laudable, again, I would like to say, where you have agreed, where you have to file first information report against your offense. So as far as I'm perceiving that these particular provisions definitely will create a very substantial effect to make this society a just society, a better society, and simultaneously an equitable society, that we are not considering about the female, we are considering about the male also, and this is the need and expediency of the society. As far as the path that has been considered and that has been addressed by my prior panelist, Professor Ritik Gupta, definitely, whenever we are talking about the electronic evidences, whenever we talk about the judicial magistrate should be there, when we talk about that there will be recording, registration is required, training is required, manpower is required, but we cannot stop these things. So we have to welcome overall these things, but some things which are missing, we are have to address those issues, and providing infrastructure, providing trainings, and providing manpower and sensitizing those issues in a broader perspective definitely will help a lot. The reformulation of these criminal laws to come out from the colonization jurisprudence. So thank you for that, and thank you for having patience. Thank you.
Thank you so much, ma'am. Thank you so much for such thoughts that has actually given us multiple points to discuss upon. So as you said, ma'am, that the ethos and the culture is looked upon in the BNSS. So I would like to ask Sikandar sir, whether do you think that adopting the Bharatiya laws empowers India to establish its legal framework based upon its culture, its social and political realities, rather than just adhering to the laws imposed by the former colonial powers? Do you think that it is going to do any good to the Indian society?
Good morning, everyone. Thank you, Ms. Vartika. First of all, I would like to thank Major General Rajendra Kumar ji and Dr. Sanjum Bedi ji for having me here. And thank you so much, my fellow panelists as well. coming to your question, that whether definitely that's the aim. I mean, that's why these three criminal laws have been brought in, and government has repeatedly said that these three new criminal laws aim to, apart from decolonizing the earlier laws which were enforced, they aim to usher in a new era wherein, I mean, the justice is the aim. But having said that, we need to go to the question which you had put to my earlier panelists as well, that the aim is decolonization, whether to what extent these new laws will help us to achieve that. Now, first of all, we need to understand what is colonization. It's one thing to say that some law was enacted at that point in time. If that is the argument to call something colonial, I don't think so. That's a sound argument. Colonial, when we use it in legal parlance, it should define what is the relationship between the citizens and the state at that point in time. That's how we can term some law as colonial. Otherwise, if we just term something as colonial because it was passed at that point in time when we were ruled by some foreign power, I don't think so. That's a sound argument. Now, second thing being, apart from the new Bharatiya Nyaya Sanhita, which will replace the IPC, and the Bharatiya Sakshya Adhiniyam, which will replace the Evidence Act. But when it comes to the Bharatiya Nagarik Suraksha Sanhita, which will replace the CRPC, CRPC was certainly not colonial. CRPC 1973, which is currently in force, it was a result of 13 years of deliberations and 4 law commission reports. So to term CRPC as colonial, I will have reservations there. It certainly was not colonial. But having said that, since now we have all 3 new criminal laws which will be in force from 1st of July, there are key changes which my fellow panelist Preeti Jain ji has highlighted elaborately, all the key changes which are there in the BNS, BNSS and BSA, and they are of course laudable. Now, I would specifically like to, as a practitioner, focus on the procedure part of it, which is BNSS, which will replace the CRPC. Now, there are certain provisions in terms of modernization of technology and the use of information technology in every case. They have been given legislative backing. We had judgments, of course, on many areas, but then they lack the legislative backing. That vacuum has been filled by way of introducing specific sections. Now, one of the ways is there's a definition of audio-visual electronic means, which has been defined now in the new BNSS, the Bharatiya Nyaya Suraksha Sanhita. And then the use of technology in various procedures of criminal justice system has been introduced, starting from, one of the laudable provisions which is there in terms of section 173, which has introduced the concept of registration of zero FIR. Now, zero FIRs were there due to judicial pronouncements that any police station without having any jurisdiction ought to register an FIR, and then if it doesn't concern their jurisdiction, they'll transfer it. Now it has been incorporated in 173. Apart from that, the registration of FIR by way of e-means, electronic means, e-FIR, it has been introduced specifically in 173. But the only catch there is information may be transmitted to the station house officer by electronic means, but it has to be signed by the informant within 3 days. Only then it will be taken on record. That is there. The idea being the swift transmission of information to the police station concerned. Earlier, the victims would have to, approach the police station, maybe physically or by calling the police control room, and then only information may be transmitted. Now, we see, especially in sexual offenses where the victims are, in trauma after having been a victim of any sexual offense, they don't come out quickly with the complaints before the concerned police authorities, and later on, it turns sometimes fatal to the prosecution case, that why the delay in registration of FIR. Now, 173 of BNSS has introduced this provision wherein information regarding commission of any offense can be given to the SHO concerned, the police station concerned, by electronic means. So that is there. So this was earlier missing. Electronic means was not there. Information had to be given in by orally or in writing. Now, that is something which is very laudable, that this provision of e-FIR has been introduced in BNS. Now, apart from that, 173 also introduces concept of preliminary inquiry in cases which are punishable with 3 years but less than 7 years. Now, this concept of preliminary inquiry before registration of FIR was also introduced in the Constitution Bench judgment of Lalita Kumari versus State of UP. The Supreme Court in unequivocal terms said that a police officer, station house officer, has no option when he or she receives information regarding commission of a cognizable offense. The FIR has to be registered. But in some cases pertaining to matrimonial offenses, commercial disputes, and some medical negligence cases, the police officers were empowered to hold preliminary inquiry before registration of FIR to know the actual nature of offense, whether it's cognizable or not, whether it's actually a criminal offense or not. So for that, 7 days period was provided by way of Lalita Kumari. Now, what BNSS does in 173 is this preliminary inquiry concept has been introduced irrespective of the nature of offense, but based on the punishment. If it's an offense from 3 years to 7 years, which carries punishment up to 7 years, then preliminary inquiry may be held. And the time period which was there in Lalita Kumari was 7 days. Now in BNSS, it's 14 days time period which has been given. Now, as a practitioner, I mean, we would see that generally there are complaints of the victims that police doesn't register FIR, irrespective of the offense. Even in heinous offenses, we have victims knocking the doors of the courts under 156.3 of the CRPC, seeking registration of FIRs. Now, by introducing the preliminary inquiry with this provision based on punishment of an offense, it will give police more powers, if we see it practically, not to register FIRs. And then, of course, we'll see courts being burdened with more such petitions seeking registration of FIRs. Lalita Kumari clearly said if it's a cognizable offense, information relates to that, no option with the police officer then to register the FIR and then see what turns out in the investigation. Maybe it may end up in a closure report or a cancellation report. But police officer didn't have this discretion, which is now there in the BNSS. Now, consequently, we'll have, as I said, more petitions coming to courts that this is a case of commission of cognizable offense, but the FIR was not registered. And then more such, inquiries and, time being consumed of the courts, whether that FIR should have been registered or not. I think that 7 days period, which was there in the Lalita Kumari, it will be seen, as my fellow panelists have also said, once cases start coming to the constitutional courts, how they are going to interpret that. Because this provision specifically goes against the Constitution bench judgment of Lalita Kumari versus State of UP. Now, apart from that, of course, the victims' rights in the trial have been given more importance, starting from the right of the victim to be provided with a free copy of the FIR forthwith has been recognized. The participatory rights of the victims in the trial have been specifically provided, which of course were part of some judgments earlier, which were not specifically recognized in the CRPC we have in force currently. But now the victims have been given participatory rights, which have been recognized in the BNSS. Apart from that, there is a specific timeline and duties have been cast on the IU to inform the victims regarding the progress of investigation within 90 days of registration of FIR. So the law which is now being brought, of course, can be termed as it's more victim-centric. Earlier, it was more between the police officers, the prosecution, and the accused, and victim was given a backseat. But with certain judgments, certain rights of victims were recognized, and then globally, the victimology and the rights of victims have been elevated, to a higher status, recognizing that perhaps the legislature has given more rights to the victims when it comes to the criminal trials. Apart from that, my fellow panelists also highlighted provisions of, recording of evidence by electronic means. Same has been provided for victims. The statement of a victim of sexual offense or rape now has to be, can be recorded by way of audio, video, electronic means as well. This apart, the audio, video, electronic means can be used for service of summons as well, which was not there earlier. Summons had to be, served through traditional means, either by hand or by post. Now it has been recognized specifically that summons may also be served by electronic means. The statement of witnesses or the witnesses can be examined before the courts or by the police officers concerned by audio visual electronic means, which of course will go to a long way to ensure that the information is recorded swiftly and the victims are not made to undergo traumatic experiences in many cases, as they had to go, going to police stations and, there are complaints coming up that victims are made to wait for long just to get their statements recorded. Now, it can be arranged if the victim is not maybe residing currently in the jurisdiction of the concerned police station where the offense took place. She may be examined by audio-visual electronic means as well. So audio-visual electronic means and recording of evidence by electronic means has been recognized in many provisions, apart from, service of summons and examining someone by such means. Now, apart from that, the statement of a victim of rape, it has been specifically provided in the new provision that, earlier as well, it was the law said that preferably it should be recorded by a who's a female judicial magistrate. Now, the provision under 183 specifically says that the statement of a victim of rape should be specifically recorded by a judicial magistrate who's a female judicial magistrate, or if female judicial magistrate is not available, it must be by a male judicial magistrate in presence of a woman. And apart from that, as I believe the earlier panelists also highlighted that forensic evidence has been specifically made part of the new BNS. As I said, these were earlier part of various rules or standing orders or some legislative backings, the judicial pronouncements. Now these provisions have been given legislative backing. We have 176 specifically, which talks about any crime which carries punishment of more than 7 years. It's mandatory that the forensic experts and the forensic team of the concerned police mandatorily will visit the scene of the crime and collect forensic evidence. Though there is a caveat there, they've said that this provision will be implemented in next 5 years because of obviously the infrastructure which will be needed to implement this provision. So 5 years have been provided. So in next 5 years, we'll see for any offense, at least in metropolitans, we still have the forensic teams visiting the scenes of crime, but perhaps in other cities, it was not so. Now with 176 specifically, any offense which carries punishment of more than 7 years, it is mandatory for the forensic team to visit that offense and collect forensic evidence. Now, apart from that, there is a controversial provision, which is under 187, which corresponds to 167 of CRPC. Now, 187 is similar provision, which was, as I said, as 167 of the CRPC, which provides for remand of the accused, judicial and police. Now, 167(2) provided that if the investigation is not complete within 24 hours, the accused, after being produced before the magistrate, may be remanded to either, depending on whether police wants police custody or not, may be sent to judicial or police custody. Now, this police custody can extend up to first 15 days. Not beyond that. It was only in initial 15 days. An accused can be remanded to police custody. Now, 15 days period has still been retained in 187 as well. A person and accused of any offense can be remanded up to a maximum period of 15 days in police custody. Now, in 167, there was a safeguard in terms of this 15 days police custody can be granted in the initial 15 days of arrest. Now, these initial 15 days have been extended up to 40 or 60 days, depending on the period of investigation of the offense. Now, police can take this 15 days remand in a staggered manner up to 40 days or 60 days. Now, what it practically means as a practitioner, generally, though it's not the law, law nowhere says so, but practically we have seen in the initial 15 days of arrest, perhaps when accused is running in police remand, police custody, courts are generally reluctant to enlarge the accused on bail because they would say that police is entitled to seek your custody, you are running in police custody, though there is no such law which bars a court to grant bail to an accused who's in police custody. But generally, courts, magistrates would be reluctant in the initial 15 days. Now, what it means now, in the initial 40 or 60 days, where this remand can be now taken up to 15 days in staggered manner, the courts will be reluctant to grant bails to the accused. Now, of course, I understand the state has its valid arguments because in many cases, what accused used to do, they would avoid police custody in the first 15 days on the pretext, once they have been arrested, they will seek some medical attention. They might get admitted in some hospital to say that they are unwell. Now, once that 15 days period used to expire, then courts would not grant the police custody. They would say that 15 days period has expired. That was the argument from the state, perhaps, that in many cases where it is important to take police remand of an accused, they avoid the first 15 days because they know the law well. After first 15 days of arrest, it can't be granted. Now that period extends to 40 or 60 days under 187. So that's why perhaps from various quarters that there is an apprehension, and we'll have to see in coming days how courts would rule on this, because only then this provision of police custody can be kept in check. Though it's only 15 days, there is, you might find some literature as well, which is a little confusing, which says that now police remand can go up to 60 or 40 days, 40 or 60 days. That's not so. Police remand will be only up to 15 days, but it can be taken up to 40 or 60 days in a staggered manner. So that might perhaps be a roadblock in terms of an accused seeking bail. Apart from that, there is another provision which is subject to little criticism, which is in terms of Section 43, arrest. It specifically has brought in the handcuffing of the accused of certain crimes. Now, we have very old judgments, starting from Prem Shankar Shukla to Sunil Batra, which have clearly denounced the use of handcuffing. It cannot be a form of punishment. Courts have repeatedly said, the Constitution bench judgments, which have said that it's a violation of human rights to handcuff a prisoner. And the only caveat there was, only condition there was, if there is such an accused where police, the escort party feels necessary to handcuff, they will have to seek permission from the court whether to handcuff this person or not. Now, what 43 does is, it has specifically provided for use of handcuffs for effecting arrest or production of, accused of, certain heinous crimes in terms of murder, organized crime, terrorist acts, drug-related crimes. This provision has been introduced, and we'll see in coming days if it's challenged on the touchstone of the earlier judgments, which we already have, which have termed the handcuffing of prisoners as unconstitutional, whether this provision will be held intra vires or ultra vires, but it has specifically introduced the handcuffing again. And apart from that, there is a specific provision which has been introduced in the BNSS. Earlier, the search and seizure proceedings under the CRPC, unless the court directed the concerned IO to videograph them, videography was not mandatory of search and seizure. Now, to introduce more transparency in such processes, and we have many cases wherein the person, the accused whose premises are searched, accuses the police officers of planting something or using illegal means during search and seizure. Now it has been provided in the BNSS that the search and seizure proceedings will be videographed. So that will go, of course, a long way in ensuring that these procedures are conducted by the agencies in a transparent manner. Earlier, it was only when the court would mandate while issuing a search warrant that this search should be videographed. Otherwise, it was not mandatory to videograph such search. Then electronic means, as I said, they have been specifically introduced. And one more important provision for which there was no timeline in the CRPC. Now, specific timelines have been issued as to when, after charge sheet has been filed. Now, to minimize the delay, now there is a 60-day window which has been specifically provided from the date of committal, that the accused may file an application for discharge. Once a case has been committed, which is triable by Sessions Court, it is committed by the Magistrates Court to the Court of Sessions. You will find in earlier cases which are currently pending, cases remain pending on the stage of charge for years together. And the accused may file those applications for discharge much later, maybe perhaps in some cases to delay the trial. Now, BNSS has specifically under Section 250 introduced this 60 days window after the case has been committed to the Court of Sessions. There's a 60 days period which has been provided to the accused if at all he files an application for discharge. So conversely, it means that within those 60 days, that is a timeline for framing of charges. So 2 months. Otherwise, we see on daily basis, there are cases which are pending on the stage of charge for many years altogether, as long as 5-6 years, case pending on charge for one reason or the other. Now, there's a 60-day period which has been introduced there. And another important timeline which has been provided for delivery of judgments. Earlier, CRPC didn't provide that after final arguments are conducted as to when the judgment has to be delivered. Now, in Sessions cases, this 258 specifically provides for 30 days period. After arguments are concluded, the judge has 30 days period to deliver the judgment. Unless, of course, there are certain factors which may be extended for the section provides that this period may be extended up to certain period again due to certain reasons which are there to be recorded in writing. Otherwise, we'll find, and we have judgments also from the Supreme Court, Anil Rai versus State of Bihar, which said that once a judgment is reserved, it has to be pronounced within 3 months. And beyond 3 months, the bench has to change. It has to be assigned to another bench. Practically, we would see that judgment, though it pertains to 2001, it is not implemented the way it should have been. Now, in BNSS, there are specific timelines for pronouncement of judgment as well. After arguments are concluded, it has to be within 30 days. And another important feature in summons cases, we had no provision of discharge. So in all cases which are, summons cases, what we term as, there was no provision for discharge. So if a person has been wrongly summoned in a summons case, the only remedy that person had either to file a revision or to file a 482 petition before the High Court to get it quashed. There was no provision for discharge. Now, in summons cases, Section 274 of BNSS has introduced the provision that an accused may be discharged if the accusation after the summons having issued, accused enters appearance. Like in Sessions case, the warrants cases, the accused has the provision of filing an application for discharge, which was missing in summons cases. Now that has been introduced in Section 274, and accused can file an application for discharge as well in summons cases. So these are some of the key highlights I would like to focus. But as the other panelists have earlier also said, we'll see once these laws are implemented. And of course, there is a confusion as well that what happens after 1st of July when these laws will come into force. The earlier laws, of course, will continue under the earlier provisions, or after 1st of July, if a victim reports an offense which pertains to a period which is pre-1st of July. Of course, we know criminal laws are not retrospective in nature unless the legislature provides so. They are prospective. If an offense is registered even post 1st July, but it pertains to a period which is before 1st July 2024, it has to be dealt with under the earlier laws in force. So the earlier cases would continue under the procedures which are there. We have IPC, CRPC, and Evidence Act. But for the new offenses and the new cases post 1st July 2024, it will be the new criminal laws. And of course, the objectives are laudable, but the trainings, my fellow panelists have also said sensitization, since they happen to be, very well accomplished academics. We all look up to them when it comes to trainings and sensitizations, be that judges, prosecutors, lawyers, or the police officers itself. There is, since I'm associated with Delhi Police, there is, the things are in place to bring in the new literature and to simplify the new laws for the officers concerned and the constabulary. Ultimately, they will have to implement these things. And we have seen the provisions which were perhaps struck down by way of certain judgments of Supreme Court. 66A is a classic example. It was held ultra vires by the Honorable Supreme Court in Shreya Singhal in 2015, 66A of the IT Act. But we, in 2023, till 2023, we had cases being registered under the repeal, the unconstitutional provision in various police stations across the country. And Supreme Court, that's what prompted Supreme Court to issue directions as well. Please sensitize the persons who have to implement these laws. So bringing new laws, of course, is a laudable step towards achieving the goals which have been, provided there. But the idea is, till the time we don't sensitize the persons who will have to implement them, that goal perhaps may not be achieved. So it's very important that such conferences like the one we are in currently are organized, and that they concerned all stakeholders, not just the lawyers or the academics, the judges, the prosecutors, the forensic experts, or anyone to do with the criminal justice implementation, are sensitized regarding the implementation of all these laws. Only then those goals of be that decolonization or to making justice accessible or to making our criminal laws more humane will be achieved, in my humble opinion. So that's all from my end. I thank you again, Dr. Major General Rajinder Kumarji, Dr. Sanjum Bedi, Ms. Vartika, and other fellow panelists. Thank you so much for your patient listening.
Thank you so much, sir. From the audience, we have a few questions for you. The first question asks for how far does the concept of justice be inculcated in newly incepted criminal laws?
See, that's a very general question, but I would try to answer that. The idea of bringing in any reform or amendment or to bring in any criminal laws, if we see the statement of objects and reasons, and while these bills were introduced into Parliament, the Honorable Home Minister had repeatedly said, apart from the aim of decolonizing our criminal laws, the aim is to make justice accessible. Of course, as I discussed, that the rights of victims have been given a center stage, and then by providing certain timelines to do certain things, by making justice accessible through audiovisual electronic means, it has been inculcated in many such provisions. But as I said, that we'll see how it will be implemented. For implementation, we need sensitization, we need understanding. We have very good judgments as well of the Honorable Supreme Court, but we see that the persons who have to implement those judgments, the directions contained therein, the persons are not aware actually. We had a recent judgment for some years regarding the bail jurisprudence, Satyendra Kumar Antil, which mandated that, which classified offenses in various categories and mandated that bail should be granted in such categories. Or we had Arnesh Kumar way back, more than 10 years back, that, arrest should not be made for the sake of it. But when we see the implementation of it, courts have to repeatedly say, please sensitize the officers concerned. Arresting officer should know there is a judgment called Arnesh Kumar versus State of Bihar, which mandates that 41A notice has to be given for offenses having punishment up to 7 years. So all I'm trying to say, laws, of course, are inclusive of justice. That's the aim. But we all need to pull up our socks and see the implementation and contribute our role at every stage, be that, one may be an academic, one may be a lawyer or a judge. We'll have to see whether they are implemented in the spirit they have been brought in for. I hope that answers your question. There are other questions as well, I believe.
Yes, sir. Sir, one of the question asked is, sir, do you think that the new law affects the rights and rights of freedom of speech and expression?
I don't think so. It does affect the right of freedom on speech. Courts are there. See, the right of freedom of speech and expression is subject to certain reasonable rights, we all know, under 19(2). And if there is an aberration from the laws, the courts are there to safeguard, to ensure checks and balances. And then, see, we can't have this argument, which is being often used when it comes to women laws specifically. My fellow panelist has dealt with, because BNS introduced a specific chapter on women and child laws. A lot of people, perhaps men in the society, have this grievance always that women rights have been given much more status and a woman can file false cases and all. It's not true. It's true for all other criminal laws. All laws which are criminal in nature may be misused. It's not just when it comes to women and child laws, they are subject to misuse. All laws can be misused. General offenses under the IPC are subject to misuse as well. There are false cases. But then we have courts. That's the reason. That's the reason, starting from the stage of remand, the accused, after being arrested, has to be produced before a judge. What is the reason that he has to be produced within 24 hours? So that the judge sees whether there are sufficient grounds to, put the person behind bars or not. So there are various checks which are there. And I'm sure if there is any such aberration, courts are there to ensure that the laws are implemented in the spirit they should be. Ma'am has raised her hand, Dr. Sanjum Bedi.
Yes, sir. No, I'm completely satisfied with your answer. Actually, I wanted to ask this to Dr. Preeti Jain that, do we think that renaming of laws is so essential? And do we attach that kind of essence of belongingness with the names of the laws? Because, ma'am, you have been teaching us interpretation, and that makes me nostalgic to ask this question to you, because I believe, whether this is taking us to decolonization or the adding or replacing of this word Bharatiya makes us to recolonize the laws. So, ma'am, I want your views on this.
Thank you, Sanjum, for raising this question, because this question is very, I feel I relate myself कि whenever we use the word भारत, तो एक भारतीयता की ये जो हम सोचते भारतीयता के साथ है, जो चीज हम लोगों में इनबाइब है, इनकलकेटेड है, अगर वही चीज वहां रिफ्लेक्ट होती है तो somehow हम उस चीज से कहीं ना कहीं निकल सकते हैं. तो I feel that this is good. But I'm not just saying कि भाई अगर भारतीय न्याय संहिता इंडियन की बजाय अगर आप भारत वर्ड लिख दे तो that will serve the purpose. I'm just inclining on this thing कि unless and until what are the purpose, objective, what are the Indian ethos, culture and heritage, and without incorporating those elements, if we are doing something, that will not serve the purpose. So yes, I appreciate, I welcome the word Bharatiya, but simultaneously incorporation of all the contents is very much essential. And I would like to take 1 minute more, and I'm very much thankful to my panelist RHS Sikandar for a wonderful elaboration, and this is the need of the day. And as I'm an academician and I belong to the theoretical perspective, but as a lawyer, whenever you are portray the procedural, what kind of things we have to go through and what kind of problems we face in the coming era, that was a wonderful. So heartiest congratulations, Professor Mr. R.H. Sikandar. It was good to hear you. Thank you. Thank you.
Mr. R.H. Sikandar, as ma'am has explained her views on this, and I believe that a comprehensive overview is workable. However, only changing of the names would not suffice the purpose. But yes, she's talking about ethos also. Could you give us an insight of how, I mean, as a lawyer, how do you think was if we had not replaced the names, if we would have not substituted the names, would it have sufficed the purpose then? I mean, is it actually taking us towards decolonization?
Ma'am, it's of course when the laws are brought in, the legislature may have something in its mind by bringing in the names they have. But I fully agree with my panelist, Ms. Preeti Jain ji. The names, of course, it is not just a name. It doesn't mean just because, even if, say, for example, we would have retained the Indian Penal Code name and named it as Indian Penal Code 2023 or 24 or Code of Criminal Procedure. As I said, it was not colonial. It was our own law in 1973. But perhaps that may have given that feeling that, the year has only changed, not the name. So by changing the names, yes, we may feel it's more belonging to our era and our country. But as a lawyer, I don't see really that name matters to such an extent unless the provisions which are contained therein are laudable and fall in line with the name, as they are named Bharatiya Nagarik Suraksha, like, I mean, the protection of citizens. So that is what should be ensured, that the provisions whom they are meant for to be implemented, that it actually ensures that the powers of various agencies are put in place, and the rights of anyone, be that accused, be that the convict as well, be that the victim or the informant, everybody's rights are well defined and they are protected. And then I feel, yes, the name falls in line with the provisions which have been brought in there. Though, of course, as earlier panelists also said, when anything new is brought in, there may be certain glitches in the initial phase of implementation, and they will be ironed out. There are academicians, there are lawyers, there are judges in this country who will, iron out, and perhaps legislature, after some time, after receiving some valuable criticism or feedback on certain provisions, for women and child laws, there is a saying, there is some criticism being made that the rape against transgenders has still not been recognized, which was there in the earlier Justice J.S. Verma committee report. It was also, it was a suggestion made that the laws should be made gender neutral, but I have reservations regarding that. But rights of transgenders when it comes to sexual offenses should have been incorporated in the new BNS, but that is not so there, though the transgender has been defined specifically. But we'll see it in coming days when perhaps the cases reach courts, how they rule, and what are the kinds of inputs which are being provided. And as I said, such initiatives are like conferences like these and the deliberations, the trainings which take place in judicial academies and law universities, where such evolving of laws and changes in laws are perhaps initiated, and then they are ultimately implemented. But that takes me to one of the questions somebody has put, Dr. Rajesh Kumar Maharwar. If I have your permission to answer this regarding the 498A, some NCRB data which sir mentions that they are false and fake. That's why Arnesh Kumar, if you have read Arnesh Kumar versus State of Bihar, why did that judgment come? It came in context of 498A cases and Dowry Prohibition Act, when Supreme Court noticed that there are rampant arrests being made by the police, not just of the husband, but the relatives of husband are also being put behind the bars by allegations under 498A. That's why the judgment in Arnesh Kumar came, though that is applicable not just in matrimonial cases, 498A cases, that is applicable in all cases. So that is where the Supreme Court brought in the check, that now you will see in 498A cases, there is no automatic arrest. In fact, in Delhi, I can say in most 498A cases, arrests don't take place, because Supreme Court there delineated the powers of the arrest of a police officer. It said just because it's lawful to arrest a person, it is not legal. So if a police officer wants to make an arrest of a person, they will have to record reasons for arrest. It is not in routine. So you will see in 498A cases, there are no arrests. But yes, you will see it is not just true for 498A. Please see, you will find it for any other case. We have cases under special acts like SC/ST Act, POCSO Act, where there are allegations that many cases are false. That's why the judges are there, to check whether a case is actually based on specific allegations, or it is just to settle some scores. But that will be true for any other criminal law. If we have to repeal laws or to criticize laws on this argument that some law is being misused, it's not a sound argument. It cannot be accepted, has never been accepted by the courts to declare a provision of law as unconstitutional. It's only on the basis of specific grounds for constitutionality of a law may be termed as unconstitutional. Misuse for that, to a large extent, belonging to lawyers community, I would say lawyers are also responsible. When a client walks up to us and says that he or she has been, in the context of 498A, it's she says she has been a victim. It's our responsibility to put facts as they are, not to improvise or to put allegations which are not born from the record just to make the case fall under certain ingredients. And then it's found out. So we have clients who come up to us, they are victims, of course, of domestic violence. But then you will find, take any petition under Domestic Violence Protection of Women from Domestic Violence Act. You will find general omnibus allegations of cruelty, of course, then there'll be impotency. In every petition, the complainant, aggrieved woman, will inevitably put, where is she putting it from? It's the lawyers who are drafting it. And then please see the, how judges will rule. You are a judge, you are having 100 matters on board pertaining to the DV Act. Mahila courts in Delhi deal with the, complaints under the DV Act. Now, when they read 100 petitions, out of 195 petitions say same allegations. Now, what is the way out to thrash out whether this is truthful or not? So, as lawyers, we also have a very huge responsibility. When clients come up to us, please put facts, please put allegations as they exist. Let's not improvise them. Let's not put a version which is not there. And ultimately, cases fall because of these reasons in cross-examination. When the victim is asked whether you drafted this FIR or the lawyer drafted this, and of course, it's seen that the lawyer has put in certain allegations which were not there. So all of us would have a role to play. Yes, victims are there. They should be given a center stage. But let's not improvise or make allegations which are wild in nature, which have nothing to do with the acts concerned. And in many cases, you will find there are allegations of under POCSO Act or sexual offenses, which the accused would say, or the judges have returned some findings were false. That should not happen, and lawyers, prosecutors have a huge role to play to curb such cases and to advise. Even if a client tells you to file a false case, please advise the client concerned that we are not going to do this. Let us not put it this way. Let us put it the way it is. I hope that answers your question.
Hopefully, sir. Thank you so much, Sikandar sir, for all the insights that you have provided us with about the practical aspects of the BSS. So I would like to ask Ruchi ma'am regarding what Sikandar sir has proceeded with, that there are more rights for the victims and in the criminal trials. So do you think, ma'am, that many argues that the British era laws are outdated and fail to address the contemporary social and legal effectiveness of the laws as of now? So replacing them with the Bharatiya laws can facilitate a more just and equitable legal system. Is what you think, Ruchi ma'am? Can you please answer?
Well, I believe that just because you have renamed a law or you have amended certain provisions does not mean that full justice would be given right now. What we have to see is that the earlier laws were also good, and the amended laws or changed laws are also good. But the main limitation or the main loophole which we face is that no effective implementation is there. The people who are duty bound to implement them, they lack awareness, or they don't implement the same. So that is the area where we need to work on. And the seminars, the central government, the state governments are giving funds to the universities, to other governmental agencies to create awareness amongst the people. So we should make best use of the same.
Right, ma'am. So anything regarding what you think about the replacement of these colonial laws and how they are actually implementing and will be implemented and will be impacting the legal reforms in India?
What? I didn't get you, please.
Ma'am, the replacement of the colonial laws, the ones that we are talking about, the IPC, the CRPC, the Evidence Act, do you think that there are certain shortcomings, and do you think that they are going to reform the legal system as of now?
See, I don't think that no, I don't think that they are lacking somewhere, or the laws were had the colonized concept as such. as Sikandar sir said, that because these laws were framed when we were under the reign of some foreign power, so isliye we have named it as colonized laws. But the laws, the essential elements which were mentioned, the procedural aspect which was laid down in these laws, बहुत अच्छे बने हुए थे. So there was no problem. The actual problem lies with the implementation of the same.
Right.
So decolonization or colonization, as an academician, I feel कि उसमें कोई change नहीं हुआ है.
Okay. So now
And
anything?
with new laws, if there will be any shortcoming, I believe the courts will interpret the same to do complete justice.
Right. And ma'am, regarding the promoting of legal pluralism, basically what we are talking about is we are comparing both the laws. We are talking about what was there in the previous laws and what are going to be implemented in the next new laws that we are talking about here. So do you think that indigenously these Bharatiya laws are going to justify the current legal system that we have, or the pending cases that we will be running through?
See, as under new laws, timeline has been given to everybody. Even the courts now are bound to conclude the case within certain time frame. The investigating agencies are also bound to complete their investigation in certain time. Their prompt registration of FIR is there. So if accountability is set under this, then yes, it will help in delivering justice. Yes, but timeline has to be followed. The problem arises when every agency makes use of the exceptional circumstance, that is, you give genuine reasons that why this timeline was not followed. Because of that, pendency of cases arises, and a case is not concluded within time, and victim feels that justice has not been delivered. So if everybody does their work nicely within timeline, तो कोई problem नहीं है.
Right. I would like to ask Chaitanya sir regarding the adoption of Bharatiya laws. Do you think that it is going to reinforce India as it is going to reinforce the India's identity as a sovereign nation
Miss
and with
Saxena,
its own
just let me
distinction?
intervene, please, because I
Sure.
think we have still Ruchi ma'am's presentation there, ma'am. I think you
Right,
have,
right. Okay.
yeah. So we
Right,
can,
right.
I mean, we can take the questions, the remaining questions later
Absolutely,
because of the
absolutely.
paucity of time. Yeah, please,
True, true.
please. So I
Ruchi ma'am,
invite
you can
Dr.
please
Ruchi
proceed.
Sapaya, please.
Yes, yes.
Thank you, Dr. Sanjum Bedi. First of all, my heartfelt greetings to one and all present here, and thank you for giving me this opportunity to be part of this seminar. As Major General Rajendra ji raised in his introduction 3 points, so I would like to first say something about those 3 points, and then I've prepared some short points for bail. I wanted to discuss regarding bail, but before that, the 3 points sir raised. First point was regarding the life imprisonment. See, when this IPC was introduced, the word transportation for life was used, but subsequently it was deleted, and the word life imprisonment was used. But there were certain, because the government was using its power, the governor or president was using its power, clemency powers. So a confusion arose that life imprisonment actually means 14 years or certain reduced number of years. So with regard to that, in 2005 amendment, the IPC clearly stated that life imprisonment actually means the remainder of life. So if any person has been awarded the life imprisonment, that means he will take his last breath behind the bars. So a person may live for, let's say, 14 years, a person may live for 20 years, a person may live for 50 or 60 years, depending upon his health, well-being, age, whatever. So, but he has to serve his natural remaining life behind the bars. Now, this confusion of 14 years or 20 years, why it has arisen is that under the present IPC, section 511, we talk of attempt to, the punishment regarding attempt to commit certain offenses. For example, if you have committed murder, under section 302, the murder has been defined, the punishment is given, the attempt to murder has been exclusively provided for, but there may be certain offenses for which attempt and its punishment has not been specifically provided. If that offense carries the actual offense carries life imprisonment and its attempt has not been defined, how will you punish that person, right? For that purpose, the life imprisonment would be taken as equivalent to 20 years. So life imprisonment actually does not mean 20 years, but for certain exceptional circumstances where punishment for attempt has not been defined, for it we take it as 20 years. And if it is provided under section 511 that half of maximum sentence, half of life imprisonment will be given, for that purpose, life imprisonment 20 years and half of 20 years means that for that attempt, he will actually serve 10 years imprisonment, right? So, so that means for actual offense for which the punishment is life imprisonment, he will serve the natural remaining life behind the bars. But if he has attempted to commit any offense whose punishment is half of life imprisonment, then we will take life imprisonment equivalent to 20 years and half will be 10 years. So he will be behind the bars for 10 years. And the confusion regarding 14 years is because let's say you are behind the bars and you have shown good behavior and for that some granted to that prisoner. So after 14 years, that person gets a right कि आपको थोड़ा बाहर जाने दिया जाए या कुछ भी जो भी concession है वो government जो है on its behalf can give, but that concession by government cannot be given before he has served 14 years. अब आपने recently देखा होगा गुजरात केस उसमें नाम स्किप हो गया जो अभी केस जिसमें जो रेप कॉन्विक्ट्स थे they were given certain punishment but Gujarat government उनको remission दे दिया, right? तो इस तरह से there may be certain cases which the political जो आपकी जो government है for political might want to reduce the sentence of the convict. तो उस चीज को avoid करने के लिए कि आपका एक government लोगों के प्रति criminals के प्रति इसलिए कहा गया है that not before 14 years such people can be granted any kind of remission. So that is what I wanted to talk about, the concept of life imprisonment. Then the other concept which you raised about was promise to marry. So yes, when you are young, you are lovebirds, you promise each other something that you'll get married and you indulge in physical relations also. But subsequently, maybe because you did not intend to get married or because of subsequent other reasons, financial reasons, social reasons, your family reasons, you are not able to get married to the other person. So can the other person file a case against you and charge you with rape? So यहाँ पे भी the problem is that there are conflicting judgments of the different high courts and supreme courts. But what I can tell you here is that if at the time of inception, that is when you indulged in physical relationship, if at that time the woman knew about the nature of the act to which she had agreed to, if she knew that to physical relationship and what she understood the nature and the consequences to which she consented to, then subsequently she cannot raise any charge against that on false promise of marriage जो है मैरिज की फॉल्स प्रॉमिस की थी और अब बैकआउट कर गया है, सो ही शुड बी condemned for rape, right? So because at the inception you knew about what you were indulging into, but yes, if at that time you consented to the physical relationship only on the condition that the other person will get married to you, अगर उसने वो प्रॉमिस नहीं की होती तो वो नेचर जानते हुए भी आपने अगर उसको मना कर, अगर वो आप मना कर देते, अगर वो कंडीशन, अगर मैरिज की कंडीशन नहीं डालता तो आपने कभी हाँ नहीं बोलनी थी, मैरिज के बेसिस पे ही आपने हाँ बोली है, देन यस, यहाँ पे कॉन्फ्लिक्टिंग डिसीजंस हैं जजेस के, वेयर इन सम केसेस दे से कि हाँ rape has been committed, in some cases they say कि rape has not been committed. But I feel that if you indulged into physical relationship just because the other person promised to get married to you, yes, rape can be pressed against you. Then third thing which you raised was about adultery. Adultery में इतना hue and cry इसलिए हुआ that because adultery was taken as an offense not against the woman but as an offense against the husband. So if your wife has indulged into physical relationship outside marriage, then it was not treated as an offense against woman but as an offense against husband, right? So husband could press adultery charges against the third party. अब involved तो उसमें आपकी wife भी हुई है और थर्ड पार्टी भी हुई है, बट आप वाइफ को नहीं उसके अगेंस्ट कोई केस नहीं ला रहे, आप थर्ड पार्टी के अगेंस्ट ला रहे हैं, प्लस वो ऑफेंस वो दो कंसेंशुअल एडल्ट्स ने इंडल्ज किया था इन फिजिकल रिलेशनशिप, सो आप उसको साइड लाइन नहीं कर रहे हैं, आप हस्बैंड को एक विक्टिम की तरह देख रहे थे. सो दैट मीन्स उस चीज को जो है ऑब्जेक्ट किया गया that it is against the dignity of woman because you are treating her as if she's subordinate to her spouse. Husband से subordinate है, husband has control over her mind and body. तो शायद ये एक reason था जिसके लिए adultery offense जो है unconstitutional declare हो गया था and it has been deleted from IPC. लेकिन इसका मतलब ये नहीं है that husband does not have any remedy if his wife indulges into physical relationship outside her marriage. Yes, he has that right. He can seek for divorce under आपका हिंदू मैरिज एक्ट है या आपके पर्सनल लॉज हैं या जो भी है, उसमें आप जो है डिवोर्स ले सकते हैं if there is such kind of physical relationship outside the marriage. बट फिर अब जो है फिर से ये एक डिबेट उठी थी दैट वी शुड रीइंट्रोड्यूस दिस ऑफेंस ऑफ अडल्ट्री इन आईपीसी, बट आई डाउट कि एक बार चला गया है तो उसको रीइंट्रोड्यूस करेंगे या नहीं करेंगे. देन आई होप कि ये 3 पॉइंट्स मैं कुछ समझा पाई. ओके. Then coming to, I actually wanted to talk about the bail provisions. In the present CRPC, we have total 484 sections, and in the new act which will come into force on 1st July, that is Bharatiya Nagrik Suraksha Sanhita, we have total of 500 sections. So in the present CRPC, chapter 33 from section 436 to 450 deals about bail provisions, bail and bail bonds, anticipatory bail, etc. And the new act, that is BNSS, under chapter 35 from section 478 to 496 deals with the same provisions. Now, why when the police starts investigating a case, there may be two kinds of offenses. One is cognizable offense and non-cognizable offense. The difference between these two offenses is that in the police has the power to make an arrest without first approaching the magistrate to request for the proper arrest warrant from it. तो आपने एक investigation शुरू की है, cognizable offences which are heinous offences or which carry larger punishment, imprisonment ज्यादा होती है उसमें, तो आपने जो है the police can arrest a person without first obtaining a warrant from the magistrate. और नॉन कॉग्निजेबल केसेस वो होते हैं जिनमें the police cannot investigate or arrest a person without first without the direction or permission of the magistrate. तो आप कॉग्निजेबल केस में कोई भी आम इंसान है, विक्टिम है या any other person can come to the police station and can lodge an FIR, और FIR जो है पुलिस कभी भी लॉन्च करने के लिए मना नहीं करेगी, आपको वो लॉन्च करनी ही पड़ेगी. और अगर there are instances where the police officer he returns the informant, कभी डांट डपट के या कुछ डरा धमका के उन लोगों को भेज दिया जाता है to so that they can maintain their record कि उनके एरिया में जो है law and order situation है, crime rate is very low. लेकिन अगर वो कॉग्निजेबल ऑफेंसेस की FIR लॉन्च नहीं कर रहे हैं, then CRPC provides for another provision that if that police officer is not listening to you, then you write a letter to the superintendent of police, उनको पूरी information दे दो, and superintendent of police either himself or he will designate some subordinate officer to look into the matter, but ultimately your matter will be heard. But in non-cognizable cases, the person approaches the magistrate and lodges his complaint with the magistrate, and magistrate may either take cognizance of the complaint or he may order for the inquiry, or third option could be magistrate now forwards that complaint to the police कि मैं आपको ऑर्डर कर रहा हूं इस कंप्लेंट में इस नॉन कॉग्निजेबल केस को आप इन्वेस्टिगेट कीजिए. अब पुलिस जो पहले इन्वेस्टिगेट नहीं कर सकती थी, अगर वो नॉन कॉग्निजेबल केस को इन्वेस्टिगेट करती तो वो इलीगल होता, लेकिन अभी क्योंकि मैजिस्ट्रेट ने उसे कहा है that you investigate a non-cognizable case, now police is bound to conduct investigation in the same case. But again, it does not have the power to arrest the person. Cognizable case में तो पहले से ही power थी to arrest the person, but in non-cognizable case, the police does not have the power to arrest the person. Now, question is that why we need to arrest a person? पुलिस को ये पावर क्यों दी गई है कि वो किसी को अरेस्ट करे, या फिर मैजिस्ट्रेट को ये पावर क्यों दी गई है that he should order for the arrest of a person? Now there are certain reasons. The first reason is that the criminal justice system wants to secure the attendance of that person and appearance of that person before the court. अब जब हम छोटे होते थे, just on a lighter note, when we were young, if our school teacher gave us some homework and we could not complete it, तो दूसरे दिन हम या तो छुट्टी मार लेते थे या क्लास में पेट दर्द का बहाना मार के हेड डाउन कर लेते थे. तो ये जो है, this tendency is inherent in a human being. तो आपने कोई क्राइम कमिट किया है, then you will have a tendency to abscond from that place or not to appear before the court, because you know कि अगर एक बार कोर्ट के सामने आ गए तो आपने क्राइम कमिट किया है, then you will certainly be punished. So just to secure his attendance and appearance before the court, so that he faces his trial, and if is found guilty after proper conduct of trial, to hear proper sentence which is to be passed by the judge, इसलिए जो है उसकी arrest जरूरी है. Second reason could be that if he has been given bail. Now bail could be granted by the magistrate or could be granted by the police also in bailable offenses. तो अगर आपको ऑलरेडी बेल मिल चुकी है लेकिन आपने बेल की कंडीशंस को वायलेट किया है, बेल की कंडीशंस में कुछ डूज एंड डोंट्स होते हैं. इफ यू हैव नॉट फॉलोड दोज डूज एंड डोंट्स, तो आपको फिर जो है आपकी बेल जो आपको मिली थी वो कैंसिल की जा सकती है और फिर आपको रीअरेस्ट किया जा सकता है. Then third reason is why you are arrested, why arrest is mandatory is because there may be a probability that you might tamper with the evidence, or you might try to influence the witnesses. तो कहीं आप ये चीज गलती कर कर आप जो है जो ट्रायल है उसमें कोई बाधा पेश ना करो, इसलिए जो है the magistrate may order for your arrest or the police may also arrest you. So this is why arrest is made. Now, what is bail? This term bail has not been defined, but under the first schedule of CRPC, a column has been made in which the offenses have been defined as bailable or non-bailable. So अगर आपको कोई भी offense देखना है कि ये bailable है या नहीं है, आपको सीधा सिर्फ first schedule में जाना है और वहां पे देख लेना है कि ये bailable है, non-bailable है and triable by which court. Now why this bail or bail bond is given, ताकि आप अगर आपको बेल दे दी गई है, योर फंडामेंटल राइट इज दैट इज फ्रीडम, आपका that fundamental right is to be protected always, and the Supreme Court has also laid down in many cases that bail as a general practice should be followed and jail should be given in exceptional circumstances only. जहां पे बहुत ही जरूरी हो जाए वहीं पे जेल होनी चाहिए. अदरवाइज जब भी आपको बैलेंस करना है between a person's fundamental right of freedom and whether to secure his attendance in the court, तो आप कोशिश करेंगे कि आप उसको बेल देकर भेज दें और आप उसको बस ये एश्योरेंस ले लें that he will be present whenever he will be called upon by the magistrate or he will cooperate with the police investigation. Now जब वो बेल लेता है तो वो अपने खुद के बॉन्ड भी भर सकता है और कई बार जो है उसको श्योरिटीज भी अरेंज करनी पड़ती है. नाउ श्योरिटी इज अ पर्सन हु अंडरटेक्स a kind of pledge that he'll ensure that this person will be present before the court. तो आप जो है आप मान लो कोई क्रिमिनल है, क्रिमिनल के दोस्त हो सकता है क्रिमिनल ही हो. So can court trust his friends now to stand as surety for him? तो वो थोड़ा कोर्ट को इंक्वायर करना पड़ता है कि श्योरिटीज भी जो है रिस्पेक्टेबल पर्सन्स हो और वो अपना जो भी श्योरिटी उन्होंने दी है, जितने की भी दी है, वो उसको ऑनर कर सके. Then there are certain cases where bail is imperative. आपको bail देनी ही पड़ेगी. So first scenario is that in bailable offenses, bail has to be given. Now, the first agency which will give bail to the person is the police, because police has arrested you. If it is a cognizable case, police has arrested you. So police, and if it is mentioned as a bailable offense in the first schedule, then police is duty bound to inform the person कि आपको हम छोड़ सकते हैं, आपका right है, आप bail bond भरिए या sureties provide कीजिए और घर जाइए. So the person, if he is ready to sign that, तो उसको वहां से bail मिल जाएगी. But if he does not take the bail, then again the police is bound to produce him before the magistrate within 24 hours, and then the magistrate can release him on bail. अब अगर कोई इंसान है जिसने 7 days तक जो है बेल के लिए अप्लाई नहीं किया है, then that person is presumed to be an indigent person, और ये presumption के basis पे जो है भी उसको as indigent person समझकर भी जो है बेल दी जा सकती है और उसकी जो conditions हैं वो थोड़ी reduce की जा सकती हैं. Then when you are arrested, and if there is a time frame within which you have to complete your investigation, police is bound to complete its investigation. अगर आपका कोई केस है which carries punishment of death sentence, life imprisonment, or 10 years or more imprisonment, then police is bound to within 90 days. And in other cases, it has to complete its investigation within 60 days. अगर आप इन डेज में इन्वेस्टिगेशन कंप्लीट नहीं कर पाते हैं, and the person was arrested and he was sent to the judicial custody, then after that time lapses, as a matter of right, that person now can claim कि मुझे bail दे दी जाए. This right is known as default bail, because the police was at default for not completing the investigation within time frame, that is 60 days or 90 days. That is why now the arrested person gets a right to be released on default bail. लेकिन अगर आपने within that time frame, if police submits its charge sheet, आप हो सकता है 59th डे पे या 89th डे पे जो है पुलिस ने चार्ज शीट सबमिट कर दी है. Now on 60th or after 60th or 90th day, now the arrested person says कि I should now be released. Now it becomes the discretion of the judge whether to release that person on bail or not. Then third condition where the person can be released on should be released on bail is that when there is a reasonable ground for believing that he is guilty of a non-bailable offense. When there is no reasonable ground for believing that he is guilty of a non-bailable offense, तो भी आप उसको रिलीज कर सकते हैं, लेकिन कोर्ट जो है फर्दर इंक्वायरी उसमें कंडक्ट करेगी ताकि आगे देखा जाए कि उस अल्टीमेटली वो नॉन बेलेबल ऑफेंस उसका कोई रोल निकलता है या नहीं निकलता है. Also, if in some cases when trial is not concluded within 60 days from the first date of the evidence जो fix किया गया है, then also it is mandatory that he should be released on bail. But this 60-day rule does not apply on court of sessions. तो अगर court of session sessions court जो है अगर वो trial hold कर रहा है, and if that trial is not over within 60 days from the first date fixed for taking evidence, तो ये rule उस पे apply नहीं होता है. But उसके अलावा कोई और judicial magistrate कोई भी conduct कर रहा है, तो फिर आपको या तो 60 days में complete करना है अपना trial, otherwise that person has to be released. Then the other scenario where he has to be mandatorily given bail is when the trial is over and judgment is pending, but the judge is sure of the fact कि क्योंकि evidence has already closed, so the judge already knows that this person has not committed the offense. So there is no fun in keeping him as an behind the bars. तो फिर आप जो है judge उसको bail दे देता है. So these are some of the circumstances where bail has to be mandatorily given. Now, there is discretion in granting bail in non-bailable offenses with the magistrate or with the courts. अब non-bailable offense है, तो नाम तो suggest कर रहा है कि इसमें bail नहीं मिलेगी, but this is not the actual case. So even in non-bailable offenses, the court has the discretion to grant bail or not grant bail. So the court will see what is the enormity of charge or nature of accusation or the severity of punishment which the conviction will entail, और क्या उसका जो है एविडेंस अभी तक जो है जज के सामने कितना है, टू सी द ग्रेविटी, द सर्कमस्टांसेस, डिपेंडिंग अपॉन दैट कोर्ट may feel it right to give bail, may feel not right to give bail in non-bailable offences. So if you feel, the court feels that there is a danger of tampering with the evidence, or a likelihood of fleeing from the judicial process, or there is a probability that the offender might commit more such offences, then it can deny him bail. Or if the court feels कि ये केस जो है शुरू करने में या कॉन्क्लूड करने में बहुत टाइम लग सकता है, तो उसको जेल में पीछे रखना जरूरी नहीं है, then bail can be granted. Also, even in non-bailable offences, if the court feels that an opportunity for preparing his defense, for meeting his lawyer, for proper access to his lawyer is necessary, then even in non-cognizable offences, the court in its discretion may grant bail. Also, in some cases where there is a health issue or age issue, or even leniency in case of female offenders, in its discretion, court may give bail to the person. Now, when you are granting bail, even the police or the magistrate, wider discretion has been given to the magistrates. Because police only has the power to grant bail in bailable offences, but magistrates or courts have been given wider power to grant bail, whether in case of bailable offences or in its discretion in non-bailable offences. Then when we talk of the powers of high courts and court of sessions or magistrates, then also the more powers are given to high courts and court of session vis-a-vis granting of bail than the magistrates. Okay. Then there is a difference between cancellation of bail and rejection of bail. Rejection of bail means when the person first requested for bail, but you denied him bail. That is rejection. But cancellation is that you first accepted, you granted him bail, but because he violated some do's and don'ts, that is the conditions of bail, then you have cancelled that bail and have rearrested that person. So that is the difference between cancellation and rejection of bail. But if, let's say, police had granted bail, then magistrate should not cancel the same, but high court or court of session can cancel the bail granted by the police. Then next, I've talked about the bail, the default bail. Then last leg of bail is anticipatory bail. Now this anticipatory bail cannot be granted by every court. This power has been given only to the High Court and the Court of Session. Both enjoy concurrent jurisdiction in granting anticipatory bail. So let's say if I want to apply for anticipatory bail, I can go either to High Court or to the Court of Session. Lekin sensibly, I should go first to the Court of Session, because what if the Court of Session rejects my application? Then there is another opportunity available with me to approach the High Court. लेकिन अगर मैं first instance में ही High Court में चली जाती हूँ anticipatory bail मांगने के लिए और High Court reject कर देता है, then I cannot say because Court of Session also enjoys concurrent jurisdiction, तो मैं अब उनके पास जाके मांग लेती हूँ. Why? Because if big brother has said no, so younger brother cannot say anything in that regard. So और ये anticipatory bail जो है, why this provision is kept, because there may be certain circumstances where due to political rivalry, false cases may be lodged against somebody or to disgrace somebody, किसी की reputation harm करने के लिए जो है झूठे मूठे केस भी बना दिए जाते हैं. You must have heard recently जो हिमाचल प्रदेश में जो political scenario हुआ, because 6 MLAs of Congress government, उन्होंने जो है राज्यसभा में की वोटिंग में जो है ऑपोजिट पार्टी बीजेपी के उनको वोट दे दिया. सो some cases were lodged against one or two MLAs ताकि वो प्रेशराइज कर ले कांग्रेस गवर्नमेंट उनको वापस कांग्रेस में ही आने के लिए. सो वन ऑफ देम अप्लाइड फॉर एंटिसिपेटरी बेल विच वाज ग्रांटेड. सो आप जो है कई बार जो है रेपुटेशन खराब करने के लिए या पॉलिटिकल राइवलरी के लिए फॉल्स केसेस कर देते हो, तो उनसे निकलने के लिए जो है एंटिसिपेटरी बेल का प्रोविजन है. नाउ दिस एंटिसिपेटरी बेल व्हेन यू अप्लाई फॉर दैट, सो द कोर्ट can give an interim order, can pass in an interim order for giving an anticipatory bail, but final order should be passed by the court only after hearing the public prosecutor. और public prosecutor को आपको within 7 days notice देना पड़ता है, so that he can also give his arguments why anticipatory bail should not be granted to that person. Now, which is the right place where that person can apply for anticipatory bail? अब हो सकता है मैं एक पर्टिकुलर लोकेलिटी की रहने वाली हूँ, लेकिन मैं कहीं और जाकर छुप गई हूँ या कहीं और चली गई हूँ. So which is the person, let's say the state machinery is not letting me come to the original place where I can file my case. तो ऐसा यूज ही क्या रह जाएगा? तो किस कोर्ट में जाकर मुझे, कहाँ के हाई कोर्ट या कहाँ के कोर्ट ऑफ सेशन में जाके मुझे एंटिसिपेटरी बेल मांगनी चाहिए? सो दिस एंटिसिपेटरी बेल can be filed, this application can be filed in the jurisdiction of court where you said it.
I think we have lost connection with Dr. Ruchi, and I'll call her and try to fix the problem. Meanwhile, may I please request Mr. Chaitanya Singh to take over? And we also have some questions here due to paucity of time, and the validatory session is also lined up. We're running very short of time, and these questions may be then mailed to the panelists, and their answers will be then delivered to the participants. So welcome, Mr. Chaitanya Singh. May I please request you to take over the panel discussion?
Yeah, thank you so much for the opportunity, and I would like to thank Dr. Sanjum Bedi for like coordinating the event so nicely and like being like behind us to like make sure the things are all in place and everything. So yeah, I would like to like, thank all the panelists for covering most of my presentation that I would like to give today. And it's like really nice to hear all of the panelists, and like I would like to focus on the new criminal laws from a critical perspective, right? Because we all know how the laws are being framed and the names have been changed. So like as the old Shakespearean saying goes, what's in the name? A rose will still smell as sweet even if you change the name. It will still be as sweet as like it was, right? So under the new criminal laws, which we call like Bharatiya Nyaya Sanhita or like Bharatiya Nagarik Suraksha Sanhita or like Bharatiya Sakshan Adhiniyam, like these laws have been like come to place to change certain perspective to go from the earlier colonial mindset to a more Indianized or Indianness, right? But we need to focus like on like what exactly do we mean by Indianness, right? And when we talk about the colonial mindset, we mean that the laws were framed back in 1860s, but now we are making Bharatiya Nyaya Sanhita 2024. But what exactly do we mean by that? Because if we go back to the colonial masters, like back in the UK, you still in UK can only stay in the judicial custody or police custody maximum for 28 days. And above and beyond 28 days in the UK, any incarceration is called illegal and unconstitutional. But in India, we are still with the new laws saying that we have those 60 and 90 days. And like how Mr. Sikandar also told, like under the new laws, the remand system has gone from 15 days maximum in the initial period of the police custody to like 40 to 60 days in a staggered manner. So are we really going from colonial mindset to a newer, like a Indianness? Like what exactly do we mean by that? And what about we should question ourselves, like, what is the reform that we are talking about? What reform should we keep in place when we talk about the new criminal laws? Because as you all know, like IPC, CRPC, and evidence, right? They are called the basis for criminal justice system. And we all academicians and practicing lawyers, we still disagree if we are actually performing criminal justice by IPC, CRPC, and evidence. So we should ask ourselves, the purpose of bringing criminal laws in any country is to provide criminal justice in the system, right? To reform societies, to reform the people who are corrupted by certain elements, right? And to make them understand that certain things are not right and they are based on immorality or like illegality. So the reformation should be at the heart of any criminal justice system, and we should ask if these laws address that. So for law students and for practicing lawyers, we focus on number of sections we have to learn and like to revise every now and then. So the section numbers have not decreased or increased; they are still more or less the same. So we'll still have to grapple with the new laws and the new verbology or phraseology the laws have incorporated. And nextly, I would like to talk about some changes, right? The changes which have been brought by these particular laws in certain areas, like in earlier IPC, we used to have 124A of IPC that talks about sedition, but the new laws have replaced sedition with a different section 152, which is titled as acts endangering sovereignty, integrity, and unity of India. But we need to focus not on the phraseology here, but on the content of the section. Because even though it is replaced, the sedition has gone. We are happy about it, sedition has gone. But is it really gone? Because the new section is more vague and more broad nomenclature has been introduced in the section. The section says that, just for example, just to tell the audience about it. It talks about whoever purposely or knowingly by words either spoken or written, and they have also introduced by electronic communication, like on Twitter, Facebook, Instagram, or other means, right? Excites or attempts to excite succession or armed rebellion or subservice activities. But what are these activities? What is the encouraging the feeling of separatist activism? Government can still charge you that you are trying to encourage certain separatist activity or you're trying to endanger sovereignty, because these are terms which are vague. These are terms which are very broad in nature to put someone behind the bars. You can just tomorrow say that, okay, so a person gives a speech in a audience, and they say that, okay, fine, whatever the person said is they are trying to raise an armed rebellion, they're trying to excite people against the integrity of India. So what exactly is the purpose, right? The focus should be on purpose. And I said before also, criminal justice and reforming the society should be at the core and the heart of any law which might bring, right? And also the usage of electronic communications under the new section 152 of the BNS, right? If you read that with the new telecommunication bill, it virtually open doors for legal interception of electronic communications, right? Because it will raise concerns about privacy, it will raise concerns about someone's human dignity. Because if you target a person, that person has been engaged in certain speech, or if a person is a political opponent of a particular party, then you will essentially and technically will allow the government or the police to intercept the person's phone or like their calls or something like that. So the usage of e-communication under the new 152 of BNS actually opens door for a lot of prosecutions. It doesn't there was a question in the chat box about will the courts be more overburdened? Yes, the courts would be overburdened, obviously. People, if you go for quashing before the High Court, people go to Supreme Court, right? So the courts would be overburdened. And I also, like Mr. Sikandar has said before, this is not reducing the pendency of cases. And another example would be of electronic evidence. And I think the panelists before me have talked already about the making electronic evidence as primary documents. The procedure of 65B of Evidence Act still remains, rightly. But when you term electronic evidence as a primary document, we should understand that electronic documents can easily be tampered with the usage of AI and deep fakes, which someone like one of the panelists talked about. With deep fakes coming into place, how do we trust the electronic evidence? Will making it primary document or not a secondary evidence? How will it work? We'll have to wait and see how the court will interpret these things. But to giving a stamp of a law, the court will be bound by that, right? Because in a criminal law, we are not supposed to give a liberal interpretation, but like stick to the literal interpretation of the law, right? So considering in mind how electronic records can be easily tampered without any trail behind it, like like how exactly the things got tampered. So it classifying it as primary evidence might be problematic and counter feature to the new laws. And also again, which I found very concerning, right? Because people might laud about it, people might praise that under the new penal codes, we have the acts of terrorism which are defined, acts of financial crimes which are defined. But for example, in the in the BNS section 113, it clearly talks about acts of terrorism under the revised bill, and which is basically it defines what exactly is terrorism. But also like just to come back to this, like the police officer, the senior police officer has a choice to either proceed under the UAPA, which is Unlawful Activities Prevention Act, or to proceed under the BNS laws. But if the act of terrorism being a heinous offense is already under place in a more stringent and a special statute, then what is the need to govern the same in the general statute? Because in special statute, there are certain protections and there are certain clauses which makes it heinous. Because the acts of terrorism, to arrest a person and to label them as accused for terrorism, it not just creates some overhaul of the criminal jurisprudence. It not just makes the whole criminal jurisprudence head to top, but it also impacts the social conditioning of the person. If person will be called terrorist tomorrow just for giving a speech, because the section again is just like under UAPA section is similarly copy pasted, and it is still the content of the section is still the same, which is vague and broad. So we need to focus on that, like acts of terrorism and all these sections. And nextly, what are the good changes? About one person asked about mob lynching in the chat box. I think original bill which was introduced before the parliament, before the standing committee, it had mob lynching and hate crime as separate category of category of murder in the first place. But the punishment was only 7 years, not like the punishment for murder under 302 of IPC. But after the committee and after the review of the laws, the enhancement of punishment on par with the murder has been done for the mob lynching as well. Mob lynching is a specific type of crime which comes under the category of hate crimes. And as one of the panelists talked about the SDGs, the Sustainable Development Goals of the UN. So UN says that we should not give punishment so enhanced that it will defunction the whole purpose of the law. Mob lynching in itself is a crime which is not just an act of, which is not just includes mens rea and actus reus. It includes a certain element of hate toward a particular community or toward a particular religion. So it is a good change which is bought by the BNS or the new laws, right? And also about mental illness, right? Because the word mental illness have a negative connotation to it, and it has been replaced by the unsoundness of mind. So this is a very good attempt by the government to get away with the connotations which are negative in nature and which creates certain dogmas and certain regressive thought in the people. So I think these are certain good changes, and along with that, a lot of changes like community service in the BNSS, and these are very good changes which will enhance the criminal justice system. Like in BNSS, the erstwhile CRPC, the community health service is defined as work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. So these things are being done currently by the courts in Delhi or around the country. But to define community service and to place it under the criminal law legal provision by a legislative measure is a good step which must be appreciated and lauded, and we should focus on these good steps to see how exactly these will transpire and how the government and how the courts will look into it. Because without any effective implementation, no law would be of any use. And as Mr. Sikandar has already talked about police custody beyond 15 days, so I will not touch upon that as we have paucity of time. But like, I'll focus more on the 3 years under the BNSS. Like the code says that a case should end in 3 years under the BNSS, and which was like a battle cry for lawyers and like for the victims and for the accused person in the court, that the case has been dragged for years and years. But NCRB data already shows, like I have done my research on it, it already shows that many cases in the country, around the country, not just in metropolitan cities like Delhi, Bombay, Bangalore, Kolkata, like a lot of in many places, the data shows that the criminal cases are getting over within 3 years only. So this putting a tagline, putting like a hammer on the judicial officers that in 3 years you have to complete the trial might be counterficial, because it might have a certain negative impact on the judges as well. Because I have seen, like in practicality in courts, that when there is an order from the High Court on the judge that a certain case has to be finished within 1 month or 3 months or 6 months, the judicial officers, like in subordinate courts, they are very anxious to give a adjournment. Because thing is, like in criminal cases, you have to have a defense strategy when you're fighting a case in a trial court, right? Because you will cross a witness today and you will leave the witness at a certain thought, so he might come prepared tomorrow and come again, and then you again cross him and surprise with a new element and get the answers out of him. So it is all on defense strategy, and these strategies must be kept in mind while drafting any new law. But this has been done and dusted now, and in 3 years you have to finish the whole thing. But if it is implemented, and if the judicial officers, the quantity of the judicial officers, the trial courts and the high courts increase, if we have more judges and more like better infrastructure, then this would be a practical possibility, which will again be a kind of a system where we should look forward to. And academicians will have a lot of burden under these new laws. Like, sorry to say, but you will have to continuously focus on what exactly is happening and how things are being implemented, right? Because these new laws will not just be a like a challenge for the lawyers and the judges and the clients, but also for academicians and also for certain NGOs and certain civil societies who should make the government accountable for what exactly they are bringing in. Because as like another panelist talked about, CRPC was 1973. It was still a new law, and CRPC in its original form, the previous 1800s law, it was really regressive, and it did not trust the police. The new CRPC actually reformed the law to a very great extent. So it was Indian in the sense, right? So was there a need? And if the need was there, should you not focus on the certain provisions which are regressive? Should not focus on certain provisions which are unconstitutional per se, which are being held and which are being running in the thread of the criminal laws, but they are still provisions which does not and will ever, like these provisions will never ever come on the same level as the laws which we have in the other countries. Like the UN has the United Nations has given certain prerogatives, like certain development goals should be there, justice should be there. So we should think on those lines, because if we focus more on India, things will not improve. We might get that phraseology that, oh, we are Indian now, we are like, even the laws are now Indian, even everything is, we are like Bharatiya now. But the prime focus, right? Prime focus should be on the fundamental nature of the laws. And we have to see if these laws are promoting the human rights, because India, being a country in itself, sovereign country in itself, is also a signatory to a lot of international treaties, right? And we have obligations which we have to fulfill. We are a party to UDHR, we are party to ICCPR, right? Not a lot of other treaties, right? So do we have to analyze if our laws are aligned to those international treaties? Because UAPA having been criticized left, right, and center by academicians, by lawyers, by jurists, by like civil societies, and even by UN itself. But still the government, instead of changing those laws which are keeping us behind from certain indexes in the global world, we are not just changing and targeting those defective laws, but we are incorporating those laws within a new general legal system. We should identify what is the purpose of a general criminal law and a special criminal law, right? A special statute will always have a certain effect. It comes to solve a particular purpose, right? So the focus should always be on the purpose. For what purpose these new laws are coming? Because just to bring Indianness and to get away with the colonial mindset is not a purpose, in my opinion. Sorry to say, but the purpose should always be to, to give certain justice to the people. Like, it has become more victim centric. Very good. But what about the rights of the accused? Because in practicality, the accused, even if the person has done something or not, it is a matter of trial, and the courts will give the judgment on that. But there are a lot of cases, and recently I give you example, like when in 1996, a trial court has convicted a person for the case of rape, and the courts, without even appreciating the evidence, the person, it was sent behind the bars, right? And in 2023, I think in December, November, a division bench of Supreme Court has overturned that judgment of 1996. So you see the time lapse which has gone in that, and what about the life of the person? So we should focus on these things, because any person who is accused of any crime is not a criminal, is a person who deserves some rights, and our laws should, cast a duty upon the police officers and to cast a duty upon the judges to make sure the not an innocent person go behind the bars, right? And in my opinion, in conclusion, firstly, we have to see how the courts will look into it, for obviously, and secondly, in my opinion, I think what we should do, like as a society, as a part of a civil society, we should focus more, and we should look into the data. Data is something which India lacks a lot in, right? Take the health sector, take any sector in the country, we lack in data. We pass diktats, right? We pass judgments, and we pass like farmans, we should do this, we should do that. But what about from where are we saying all this, right? So these data should be collected very wisely, and it should be made public, and people should look into that data from different perspective, from academician's perspective, from a lawyer's perspective, from a perspective of civil society and a common citizen. If we don't do that, then any law, not just the criminal law, any law will not be fruitful, right? So, and also one more thing I would like to highlight before concluding my presentation for today is that the rights of people who are underprivileged, who are marginalized, who belong to a minority community in the country. What about those? Because we talk about legal aid. Is the legal aid which the court gives, which the government gives, is it enough? Will these laws make those people at the center of the purpose of these laws? Because a rich person can get a bail very, very easily in a court of law. We have seen yesterday only, I was talking to one of my colleagues, Arvind Kejriwal, the CM of Delhi, got arrested, and he approached the Supreme Court at 12:30 in the night, and the matter got listed today itself. Right. So people who have riches, people who have money, they can do things. People who are in power, they can do things. But a person who is underprivileged, who is from a marginalized community, for them, what is the protection? So these laws must be analyzed from that kind of lens. What is it for the general public? Because if we talk about Indianness, it is true, and it is not sedition to say that India is a developing country, and we, even though having very nice infrastructure, we are still a poor country, and still there's an economic divide is too high, and people are not even aware about what is their right to file an FIR. As simple as that. So when the situation is like that, that is Indianness. The Indianness is that we are unaware of criminal laws and our rights. We don't have any money in our pocket to hire a lawyer. That is Indianness. We should focus on that and resolve the systematic issues. And once we resolve the systematic issues, then no one will stop us from becoming whatever superpower we want to become by 2025 or 2045, right? So these are things which the government should have been focusing on, but it's all right because there's a majority in the parliament and we cannot talk about it anymore. So it's, as academicians, as a person from outside the system, we have to, deliberate, and we have to have more such conferences, probably in person, where we can talk more freely without any fear and without any prejudice which might be caused. We should have these more conferences, and in every part of the city, people should go for legal drives and legal aid. As my piece of advice to any law school, I always say that because I have done that in my law school in Bangalore. So the focus on legal aid should not just be just for the perspective of BCI ka regulation pura karna hai. We should do that also to educate people about these things. What are their rights? And we should pick one student from every district from where they come in the local area and should place them there 8 miles. It will give them a lot of work also in litigation. They'll not go from here to there finding work. They'll have a lot of work also in the area and people help people also. So that is it from my side. And if you have any doubts, please let me know. Thank you so much.
Thank you, Mr. Chaitanya. It was a wonderful, wonderful comparative analysis of the new laws and the earlier laws. We thank you for being there with us. I may please ask our anchors to take over now.
Thank you so much. Thank you.
Thank you to all the panelists for giving your precious time and for enlightening us with your wise thoughts over the replacement of the new laws. It was indeed a very insightful session. And for further, you may join the valedictorian session. Thank you so much, everybody.
Thank you.
The questions that we have in the chat box, we will mail them to our respected panelists and we'll get the answers and then post them to the audience. Thank you, everyone.
Thank you so much.
Thank you so much, ma'am. Thank you, everyone.
Thank you so much, everyone.
Thank you.
Thank you.
Congratulations, Dr. Hartis. Congratulations, Dr. Sanjum, for taking this wonderful initiative.
Thank you.
Thank you, ma'am. You
God
have
bless.
been my
God
mentor,
bless.
my teacher. I have learned from you. Thank you so much, ma'am.
God